My lord, upon notice to the opposite parties, I am seeking my lord's kind indulgence to mention, my lord, item number 337. My lord,
What do you want? Upgradation?
my lord, this matter had appeared, my lord, upgradation.
Upgradation, please hand over the slip mentioning the urgency.
Permitted to mention, my lord. My lord, this is for upgradation.
Please wait. Upgradation, please hand over the slip mentioning the urgency. Upgradation, any matter, please hand over the slip excepting contested application.
Lord, please 1127, Lord, item number 1127. I had indicated on the last occasion, Lord, a very short direction will be required. I've indicated the urgency, Lord.
My lord, on the last occasion, I have mentioned it with the upgradation slip, my lord, but it was not allowed, my lord. Kindly.
Madam, please indicate the urgency if I find, because madam, I have to consider the inter se urgency. So if all the matters, if you want, yes, has to be upgraded. All right, I will upgrade the entire list.
But
So
my lord, I have mentioned,
then
my
it's better, madam. Then I will proceed serially.
Yeah.
I think that's better. I will proceed serially. I will not upgrade any matters.
lord.
I think that's better.
Quantum of
That is, madam, you have one urgency, others have another urgency. I have to
Yeah.
consider the inter se urgency. And if all of you want your matters to be taken up, then I will proceed serially. Choice is yours.
Your lordship, ready?
God bless me.
Your lordship, ready?
Extension of interim order. Extension of interim order. Please hand over the slip.
Extension.
Please wait. Extension of interim order. Please hand over the slip.
Extension.
Applications, please hand over the slip.
Application, sir.
All applications, please hand over the slip.
My lord, application for restoration.
Any application, please hand over the slip.
Any application. Blood inclusion.
Inclusion motions only, please hand over the slip. Hand over the slip. Please hand over the slip mentioned.
Your lordship, matter.
Favorable circumstances, I mentioned this matter. Mention this matter for upgradation.
Please hand over the slip.
When the opposite party filed a writ petition before the writ court, and I filed a revision against the municipal appeal. And writ court fixed the matter on 5th August. Any day before 5th August. If the writ court passed the demolition order, my revision will be infected.
Why?
Yes, my lord. Because I also challenged the demolition order.
Hand
By
over the slip.
municipal
Hand over the slip.
Before 5th, my lord.
Please hand over the slip before 5th. It's not possible. So up to
Your lordship,
I think 21st of August, everything is full. After 21st of August.
lordship,
First of August, I will consider. Not before that.
your lordship, mention a matter of restoration. Should you hand over the lordship? Your lordship was pleased to direct that it will come in a monthly list.
Reckoning. Yes.
Lordship.
Yes.
So the matter also.
With justice.
Justice Supratim Bhattacharya.
Yes, I think Shukrobar to. Here. Hand over the slip.
Miller,
This matter, petitioner's daughter.
Please use the microphone.
My lord, in this matter, petitioner's daughter is suffering from major hearing problem, and the doctors of Kolkata is saying to do urgent surgery. But in petitioner have taken an appointment in CMC.
You want upgradation? Please hand over the slip.
My lord, kindly fix the matter before 31st of July.
Please hand over the slip. I will consider.
Milord.
Yes.
Lord would remember, this is the matter Honorable Justice Shampa Sarkar had already granted expeditious within 6 months. Thereafter, Milord, I have mentioned 5 times, Milord. It has not been appearing in the monthly list. On the last occasion, your Lordship had also upgraded it. Milord, kindly fixes up it any day of the week. On the last occasion, item number 40 in the monthly list, Milord.
Hand over the slip. Yes.
Milord, mention one matter.
this matter as per your lordship's order coming to this list, but unfortunately the matter is not in the list. So I'm praying before lordship's on listing of the matter. I've annexed the order.
Daily list also, my lord, besides the monthly list, because it's coming up only in the monthly list, item number 40, my lord.
Please hand over the slip. I have to consider. I cannot consider peacefully in your matter. I have to consider all the urgencies, sir. Consider the inter se urgencies.
My lord, this file was lost, my lord. After that, it was located in this court, my lord, would remember.
Yes.
Mention lordship for arbitration of the
Please hand over the slip.
My lord.
that lordship, the order.
Sir, mention the urgency. Hand over the slip.
এইটা আমি দিচ্ছি যেটা inclusion.
Hand over the slip.
Lordship, they are getting third party interest.
Lordship, application
Please hand over the slip.
application under section 24 in monthly list of the lordship list. Lordship.
24.
Under section 24.
এই ওটা নিন তো section.
শুনো স্যার, ঠিক আছে।
What is the item number? 951. একটা order record করে দিন। order 959.
Matter has been assigned by the Honorable Chief Justice. It's a case of police inaction, my lord. Item number 203, my lord.
ওটাই assigned matter টা দেখে দিন তো। Assigned group. Assigned. You have mentioned it's assigned.
Assigned matter.
You have mentioned it in the list. Already. Please hand over the slip.
Can it be taken up tomorrow? my lord?
Contested application, lordship. Listed motion, listed motion. For inclusion of a contested application.
Contested application, please don't mention for inclusion.
Lordship, may I be permitted to mention a matter of inclusion? My petitioner is a widow and she has been outstanding. It is under CO of 2665.
Sir, contested application and motion, what heading?
CO.
CO, there are different heading. Please check up their file.
Due to extreme urgency, my lord, I mentioned. My lord, previously mentioned several times.
For upgradation.
That is 2 p.m. fixed, my lord. 2 p.m. fixed tomorrow. Urgency is there, my lord.
What is the item number?
Item number, my lord, 143, my lord.
Give a mention slip, I will consider.
Petition will become infructuous if it is not heard before 31st July, lordship.
Why, madam?
Lordship, the order that has been challenged, that has been cancelled of free fair election, and if it is complied, public property will be encroached. Already they have started
I
encroaching.
could not follow. What is the impugned order?
The impugned order has been passed by the Cooperative Election Society, and it has
Yes.
cancelled a free and fair election, and therefore they are conducting a new election in an arbitrary manner. Therefore, lordship, if the matter is not heard before 31st July, it
Yes,
will become
yes,
infructuous.
please hand over the
May I
slip.
have a lordship's kind mention, my lord?
Emergency. The matter is fixed in trial court on 28th this. I have made substitution application which has been rejected.
All right, hand over the slip.
The matter does not be heard. It will be rejected by trial court on 28th.
Hand over the slip.
Fixing the matter tomorrow at 2 p.m.
Please hand over
May I
the
have a lordship's kind, my lord? This matter was
Mentioned it several times.
Yes.
It was allowed, mentioning was allowed on Thursday. Despite of this, this is not appearing in the list.
দেখে নিন তো।
This matter was taken up by your lordship. This was made returnable in the monthly list of July under the heading listed motion, my lord. It is not appearing, my lord. I'm praying.
July listed motion হিসেবে আছে।
New motion stage, my lord.
Please hand over the slip.
My lord, may I be
New motion, what is the date fixed?
Date is not included in the list.
Why?
Of 2002.
What was the date mentioned in the presentation form for listing?
My lord, it was 434, item number, it was early, March early, my lord, it was right.
What was the date you mentioned in the presentation form for listing? Show me that it has not listed. None of the matters in the presentation form, the date you have mentioned, all the matters till today has been listed.
I cannot recall my.
Didn't say that it has not been listed. Must be,
Sorry,
you have paid for adjournment, it has been adjourned. That's the reason. You have paid for adjournment.
my lord.
So, what was the date mentioned in the presentation form? Please check up, then mention.
My lord,
Let me see,
my
because
lord,
I have also to check up whether they have missed it or not.
my lord, day after
See, what
tomorrow.
was the date, then mention. Don't
Day
mention
after
now.
tomorrow is the next date in our trial court. Order 6 Rule 17 application has been
Hand over the slip,
rejected.
hand over
My
the
lord, may I
slip
be
for
permitted to mention a matter, my lord? Matter was made returnable in the second week of July, your lordship. Liberty was granted to us, my lord, for mentioning the matter. My lord, pleadings are complete, your lordship. Contested application.
Contested application, please don't mention now.
My lord, may I be permitted to mention a matter?
My lord,
Extension, my lord. Extension of increase, my lord, that 2000 application, since it has been, my lord, beyond time, my lord.
Yes.
my lord,
My lord,
I am suffering an order of injunction, your lordship. And then this is
So contested application, it's difficult. If you want, I will include all contested applications. I do not have any difficulty. If you want contested applications to be given preference, I will take up contested. I do not have any difficulty. You please decide amongst yourselves. Fix the date when contested application, I will be taking up contested, but no mentioning for upgradation of notions. That I will specify. No upgradation mentioning. Yes, I will take up contested. I do not have any difficulty. I can take up contested application from 10:30 itself. I have no difficulty.
My lord, may I be permitted to mention one matter?
Yes.
My lord, this is a contempt application. My lord had passed.
Please hand over the slip.
I would not have bothered your lordship, my lord, but with the matter. Hence in this matter is that the petitioner before lordship is a 78 years old lady.
You want upgradation?
Not upgradation, my lord. This matter was taken up for hearing by your lordship. Pursuant to my lord's direction, the matter was directed to appear on 22nd. The matter is appearing in the list.
Yes.
But the problem is that the trial court has fixed the matter for evidence of the plaintiff, the sole witness, who is a ailing lady, my lord, bedridden, my lord, on Monday, my lord. If the matter is not taken up before, my lord,
Please, mention that in the.
My lord, I have mentioned, my lord.
Lordship, on compelling circumstances, I am mentioning this for leave to file the civil revisional application.
Yes, what is the grave urgency?
Difficulties are not urgency. Difficulty is that this is arising out of a non-appellable order of the commercial court. Now, when I'm going to file before the filing section, they are saying that first of all that you have to file it before the commercial division. It is not an appeal. This is a revisional application, and also has to be filed by online mode. But the online mode. But this is a civil revisional application. This is not an appeal.
But I think
I have the notification. It's only in respect of civil appellate division of the High Court, say an appeal coming from the commercial courts, not a civil revisional
what is the
application.
nature of the order?
Execution application has been finally disposed of against me.
All right, leave to file. Yes.
Lordship, may I be allowed to make?
Volume,
Lordship, in an earlier occasion, this
What
honorable
do you want?
Lordship, there was an order for expeditious disposal, but the court below is ignoring such
What do you
order.
want? Inclusion, upgrade,
Lordship, inclusion.
inclusion motion. Hand over the slip.
I'm saying
141.
Upgradation.
Upgradation.
Hand over the slip. Please, hand over the slip. I will consider. It's very difficult.
Yes, yes.
I have to proceed on the basis of the
know.
limit of the trial court. It's difficult.
But matter is ultimately disposed.
I have to consider because
Your lordship was very pleased to upload the matter. The police are in the name of visitation, the opposite party is bringing the there is no order. And there is an interim order from this court, your lordship. And this you have to just hear once and finalize this.
contested application.
It's on visitation, your lordship.
Contested application or motion.
Contested application.
Contested application. Please
my lord,
mention
it is
after
a,
some time. Not
may-
now.
It's already going on for a long time, your lordship. Just
My lord, may I be permitted to mention a matter? The matter is under new motion, and it is a partition suit, and my petition.
Hand over the slip.
I have
Yes.
Item number 357.
Yes, I will consider.
Item number 357.
I will consider it's difficult now because there are contested applications. It cannot be reached, sir. No use adding those matters in the list. Please, I will, once I can take up those, I will add.
is giving orders, your lordship. Why?
Yes.
357, my lord, the resolution application during stage of motion, my lord. On 7th, is it any date suits your lordship, any time?
Restoration application. What is the item number?
Item 357, my lord. I mentioned this.
Please, supplementary list.
There's list 357.
Tomorrow, tomorrow it will be taken up. Tomorrow.
Any time, my lord, any time your lordship, I shall.
Tomorrow, these applications will be taken up.
At your lordship.
Yes.
And that could deeply apply to your lordship.
Permitted to mention item number 234 of the daily list for upgradation.
For 78 of the monthly list, my lord, for upgradation, my lord.
Hand over the slip.
My lord. This was already attended by you. Looking at the perversity, you said you will hear it within a week. No stay was granted.
Right. Hand over the slip.
To mention one rest application.
Hand over the slip. Please, call the list.
I have checked it. It was 11th February, my lord. That was the date for first hearing date, my lord. It was
11th of February.
11th February, my lord. That was mentioned in the list.
11th of February it was mentioned. They can enter.
My lord. My lord.
Yes, call the list. Will consider. Yes, call the-
Item number one for the petitioner. Your Lordship, during the pendency of this application, Your Lordship, the opposite party has died. Accordingly, I have filed one application for substitution, Your Lordship. I want to dispose of that application prior to expiry of the interim order, Your Lordship. My humble prayer, let the matter go out of the list for the time being with the liberty to come back, Your Lordship.
You are for the opposite party.
Opposite party, my lord. This is opposite, sole opposite party, my lord, has been died on 21st December. They have filed substitution application after abatement.
Lordship,
Eviction is abated.
Lordship, the abatement is 3 years, Your Lordship. Your Lordship.
Who died?
Opposite party
Opposite
number, opposite party.
Sole opposite party.
Sitaram Josh.
Yes, Your Lordship.
When he died?
21st December 2024. Maybe I have been mentioning.
1st of December 2024.
Yes,
Also, limitation for substitution is 3 years.
Yes, it has been filed on 3rd of January 2025.
no.
Also, can two is my application, can one probably my current friend as well.
Can two, man. That is the substitute.
Can 2, what is can 1?
Can one, madam, I have filed for addition of party. Madam.
Oh, that can 2 is not here.
Item number 2.
You have to
I have a matter to mention, my lord.
yes,
Line, but 2 times I have mentioned, my lord, but the matter has not been yet it mainly straight. CO number 1594, I have already given my name and
yes, yes.
already mentioned 2 times, my lord.
The compilation of the document your lordship will have directed the petition.
Your Lordship, in this matter, the notes are ready, Your Lordship, for the opposite parties, Your Lordship. I seek a short passover in this matter to submit the.
You can file it by today.
Your Lordship.
আচ্ছা এ করে দেখে নেবেন না হলে ট্রান্সক্রাইব করবেন না written notes filed by the rest.
Kindly give a direction to the court officer. I will hand over the in mentioning
Number 3. 3 to 3 p.m. One thing that I have not reiterated or annexed the judgment which has been relied and handed over the copies. That's all. You have mentioned that in your notes. Thank you for not making it bulky. Yes. Yes, who is appearing in item number 5?
For the petitioner, Lordship.
Yes.
Also, order passed by your Lordship on
Extension of interim order.
Lordship.
You are appearing.
Your lordship, my client is senior citizen. And my lord, your lordship can order, my lord, your lordship, any pass any order, my lord, disposing the, because my lord, title should be filed to 20. Now, my lord, 4 years, my lord, filed a written statement, time, filed an application for supplying the documents.
Lordship kindly fixed up the date of hearing, Lordship.
And a fixed for no, my lord, you are disposing the application. Any order, my lord, get back. Because through this stay on further proceeding, naturally, my lord.
July.
Where is your written statement? Where is your written statement?
Written statement Lordship could not file because the relevant document was not annexed. That point was that
I have seen you could not file. I'm asking you, where is your written statement? Do you want to file written statement or you don't want to file written statement?
Lordship, copy of the relevant document was not served upon the plaintiff, Lordship. That's
Sir,
why.
Now you can file a written statement, yes or no?
Lordship, I shall file the written statement.
Within how much time?
As your lordship.
I'm asking you, please give me your time. Don't leave it to the court.
Lordship, kindly give me 2 months.
Sir, I think you are not interested to defend the suit.
Lordship,
I was thinking in terms of hours, but I have left it to you.
As your
I
lordship,
thought it will be
as your lordship,
in terms of days. Now you have gone to months.
as your lordship, as your lordship, as your lordship, as your
Sir,
lordship.
your written statement has been not been filed. Suit has been fixed for ex parte hearing. He is conceding. Now you are saying 2 months.
Lordship, as your lordship.
Tuesday, come with the written statement. Next Tuesday, come with the written statement.
Lordship, interim order was expired on.
I will not extend. Please come with the written statement Tuesday. I will dispose it of here and now.
Only my lord, paragraph 11 and 16, he admitted that the delay in filing the issue statement and my lord, he is
Now, Mr. Bhattacharyya, you said that any order, so you want the written statement to be filed or you don't want the written statement to be filed?
2020, my lord, by filing the issue statement, back the order, and from filing the ex parte hearing, he my lord,
So what do you want? You want with the written statement or without the written statement?
I leave to lordship.
Or don't leave it to the court. You tell me what you want. Don't leave it to the court. If you say that I have to consider whether the learned trial judge was right in fixing it for ex parte hearing, I will consider that. You said you have left it to the court. If you want, yes, he should be permitted to file written statement to contest within a time.
I cannot say, my lordship, send this matter, man, I cannot, but your lordship, to protect my lord, plaintiff's landlord's right, because my lord, on 20, my lord, your lordship, the total my lord case, my lord, admission of the revision application 11.
Yes.
Lordship possible, because suit is still now, my lord, stay eligible. All further proceedings.
When the suit was fixed for ex parte hearing? When the suit was fixed for ex parte hearing? What is the stage of the suit?
It's for eviction and my lord,
What is the stage of the suit?
my lord, only for direction for filing the register.
Only direction for?
Filing the register, well,
Show me that order. By which order?
yeah,
Citation and order filing.
So your evidence has not yet started. So I'm directing them to file written statement. Tuesday, bring your written statement, draft copy of the written statement. Yes. On the pair. Statement. Yes, next.
number 6.
Yes, Mr. Basu.
Milord, I am for the defendant petition in this particular matter, Milord. This is for expeditious hearing of the 2007 suit. It is in the peremptory hearing for the past 3 years. He's been taking time. There has been last chance, special last chance, and only special last chance if the evidences are put in. This is the stage. 2007, and it's a deed of gift out of which the purchase sale was done. I obtained the particular property, Milord. And thereafter, the daughter started putting up this case, stating therein that the deed was not correct. Everything has been done, handwriting expert, everything, to the bureau, everything has been done. For the past 3 years, nothing has been done. Can you see the last orders I've taken out, last few orders? My lord, the orders are the last 4 pages. Today is the date fixed. This is the order of August 2024. The date fixed for parental last chance. In view of so and so, Lord, let the case be adjourned for the due for the ends of justice fixed.
June 2025.
10th of June.
Yes. It was fixed for peremptory hearing. What happened on 10th
Yes.
of June?
They filed an application, petition out there stating that a revision of the application is pending. There is no revision application pending. Kindly seize one of the revision application was disposed of 2024. An advocate's letter without any definition. kindly cease, my lord.
Written statement has been filed.
Everything has been,
Issues have been framed.
yes, everything is. I'm
This application under Article 2.
Beg to appear for the petitioner. Milord, 7 or 8 are similar matters in nature, Milord. My application under order 23 rule 1 was rejected. Milord, 4 pages from the last is the impugned order. 4 pages, Milord. It was together, so everything together was in annex.
Your order 23?
Rule 1, Milord, for withdrawing the suit for filing afresh, leave to file afresh, Milord. That was
Rule 11 allowed.
that was allowed. That was also
Sir,
allowed.
order, sir.
Yes, that is there.
So,
But Milord, order
do you
7
want?
rule 13 is also there. It wouldn't affect me. Order 7 rule 13 is there. If it is rejected, it does not preclude from filing Milord afresh.
File afresh. Nobody is
Yes,
stopping you from that.
if my lord would kindly observe that much
What?
while rejecting. This
11 order. So
Uh,
you don't want to challenge order 7 rule of
as order 7 rule 13 is there, that is why. If that observation is there,
No. If you say that you want to file in view of that, I will record that. If you pray for leave to approach the appellate
my
court,
lord would record that. My lord would record that.
what?
That my lord, it was the order 7 rule 13 provision is there. That is why, my lord, I am not pressing.
So you are admitting or you are accepting the order under order 7 rule 11.
My lord, yes. Yes, my lord, because it was.
Then withdraw the civil division application.
I shall have to take. I shall have to take instructions for that.
This you don't have to take instructions.
It's a legal submission. That is why, my lord, I was.
You are practicing.
Some years, my lord.
How many years?
9 years. 9 years now.
9 years. Yes. Next.
Item number 9.
I am for item number 9, my lord, maybe make a joint prayer, my lord. My lord, the petitioner has come up against a impugned order, my lord. The proceeding is under partition, for partition. Now, my lord, it's dispute between the brothers. My lord, I being the elder brother, my lord, want to withdraw the suit. My lord, the difficulty is this, my lord, I want to have it on affidavit, my lord. Otherwise, my lord, later on we'll fall in difficulty.
You want to withdraw the suit, you have to file that application there.
No, my lord, I will record, your lordship would kindly record my statement that the plaintiff wants to withdraw the suit. That for that, my lord, I need an affidavit, my lord. That is my
That
limited.
you have to file before the learned trial, Judge.
My submission before your lordship.
Yes, that I will record.
No, my submission, my lord, the advocate on record will fall in difficulty, my lord. To kindly adjourns it for 1 week, my lord. I'll come with a proper instruction, with a written instruction.
No, Mr. Banerjee, please kindly come to the impugned order.
Yes, ma'am.
Impugned order, only a date has been fixed in the miscellaneous appeal.
Yes.
So considering that I'm not passing any orders, you take steps in the learned trial, Judge. What steps you want?
But my lord will not record because
I'm not recording everything. I will only record since 28th of July is the date of appearance in the miscellaneous appeal. I am not entertaining this.
my lord can. My lord, we'll give an undertaking to that, and the suit will be withdrawn. Then the list will enter come to an end.
File an application there. I think this.
My lord, item number 10, I beg to appear for the petitioner. My lord, I have been appointed by the Legal Services Committee, my lord. The petitioner before your lordship is 100% blind and a senior citizen. My lord, on the first occasion, my lord, he did not lay evidence because of medical emergency. Now, on the 3rd of March 20,
Banerjee, 23rd of May was fixed for argument. What happened on that day? That's the last order.
my lord,
The prayer for adjournment was rejected 23rd of May. Today we are on 23rd of July. What happened?
my lord, difficulties is they have come through Legal Services Committee, my lord. I had,
But if the suit is disposed of, arguments is
I don't think that.
so
my lord,
adjournment prayer has been rejected. Evidence closed.
yes, evidence closed. What has happened, my lord? Kindly takes the previous order, March 3.
Yes, but if it is Mr. Banerjee, can you take instructions?
And I tried to call Legal Services Committee is there, and I tried to call. I couldn't get. Kindly adjourns it. May I write a letter to them, my lord?
No, you can get the status report from the website also. That's available.
But sometimes
Not available.
no, I have not checked. But sometimes, my lord, I tell
I
you.
can ask you to serve, but it's difficult to pass an order of stay now. That's the difficulty. Because I do not know whether in the meantime it has been evidence has
And
been.
unless there is an order of stay, my lord, kindly adjourns it for this day, my lord. Let me try and get in touch with my client. My lord, though I have tried.
Passing it over, please tell me in the course of this day. Pass over.
Item number 11.
Item number 11, my lord. Am I audible, my lord? Item number 11, my lord. I'm appearing.
Unmute karo.
Now shifted to virtual mode.
No, my lord, I was not feeling well today. That's why, my lord, today appearing in virtual mode, my lord.
Then you can take rest, Mr. Chatterjee. Why are you straining yourself? Yes.
Now, my lord, defendant is the petitioner before my lord. The revision is, my lord, directed against an order whereby, my lord, my prayer, my lord, for my lord, additional repairing, my lord, has been turned down by the learned trial court, my lord, by observing that, my lord, it is no more a repairing. Now, my lord, if my lord takes up the impugned order for once.
Where is your application?
Yes. My lord, the application, my lord, is at page 61. But what happened, my lord, initially my application for repairing.
It's reconstruction.
No, my lord, I tell you, lordship, kindly reads the, my lord, inner lines of the application, my lord, though it is nomenclatured as reconstruction.
There is reconstruction, Mr. Chatterjee.
My lord knows, my lord, there.
Reconstruction. Your prayer says reconstruction.
No, might be, my lord, kindly see even a falling down of wall considered to be a repair application.
Mr. Chatterjee, if the walls have fallen down, where can be the existence of a room, Mr. Chatterjee?
No, kindly see, that's why I want to take to the, my lord, pleadings in the application, what happened, my lord. Kindly takes down, my lord.
Yes, versus reconstruction.
My lord, difference is, my lord, suppose, my lord, what happens, my lord, in case of certain repairs, my lord, replacing of falling bricks, my lord, is considered to be repairs. Now, my lord, in that situation, even the building rules also says, my lord, in case of bricks which have fallen down, which needs replacing, my lord, there is no change of structure, there is no requirement of plan.
This is the
And,
stage,
my lord, our code.
this is the stage of the suit.
My lord, suit, my lord, at the stage, my lord, at peremptory stage, but trial has not commenced.
So I'm expecting the suit.
My lord,
before you can reconstruct, the suit can be disposed of.
My lord, even that, my lord, if I go in appeal also, my lord, then also I need to live in that, my lord, the concept of repairing, my lord.
In the appeal after the decision of the suit, you will take a decision whether you will be repairing or not. Reconstruct.
My lord, whatever, my lord, the concept of repairing, my lord knows better than me is to, my lord, protect the Tenant.
This application.
My lord, kindly appreciates, my lord.
Yes,
My lord,
yes.
kindly appreciates, my lord. Kindly takes up, my lord, my application. What happens, my lord, at the time by virtue of which repairing was allowed. My lord, and while repairing, my lord, a portion of the wall has fallen down, otherwise other portions are remaining. So, my lord, I made an additional prayer with this application. The portion which has fallen down apart, my lord, allow me to replace that by the bricks by saying that reconstruction. Now, by the impugn order, court says, my lord, this is a reconstruction, so I will not allow.
No, that
Now,
is
my lord, this is
Mr. Chatterjee. It's not the court saying. It's you who have said reconstruction. That's your as well as in the body of the application.
No, my lord, kindly says requirement. May I read, my lord, for my lord, the portion, my lord. My lord, my lord, হুজুর আদালত উক্ত রিপেয়ারমেন্ট দরখাস্ত অ্যালাউ করিলে এই প্রতিবাদী চালের কাঠামো খুলিতে আরম্ভ করিলে উত্তর দিকের দেওয়াল ভঙ্গুর হইয়া পড়িয়া যায় এবং পূর্ব দিকের দেওয়ালটি চারদিকে ক্র্যাক হইয়া যায়, ভাঙিয়া যাওয়ার সম্ভাবনা রইয়াছে।
Hearing is not Mr. Chatterjee. It's reconstruction.
My lord, kindly I would rely upon a decision, my lord. I know, my lord, this would fall, my lord, our age-old decision of Calcutta High Court, where says this kind of constructions are repairs.
Yes.
My lord, kindly relies upon, my lord, 1991, my lord. Two page and page 28, my lord. Kindly takes up, my lord. Paragraph 13. My lord, all decisions, my lord, age-old settled propositions have been considered in paragraph 13. And, my lord, our High Court and Honorable Supreme Court has been recorded, my lord, in paragraph 13 at the later part, just before paragraph 14, my lord, will see. Lord, may just, without troubling my lord with the entire paragraph, the same view, my lord has got, my lord, the Commissioner of Income Tax versus Rama Sugar, my lord, portion. In this case, reconstruction of a was held to be a repair. So also such and such, my lord, that if one of the four walls of the tenement house fell down on account of rains or other external causes, it will tentable repair. Substantially, the same view has been taken in Commissioner of Income Tax, such and such, reported in such and such. Supreme Court also considered the meaning of term repair in such and doing so referred such as these cases. By referring this, my lord, our High Court has allowed the repair, my lord, of a nature of a reconstruction, which requires replacement of the entire beams.
Yes, where is the subsequent decision, Mr. Chatterjee?
My lord, subsequent, my lord,
repairs versus reconstruction.
My lord, repair versus reconstruction, my lord, subsequent, my lord.
Repairs, what is reconstruction? Please give me that decision. Because you have done a thorough research work on this. So you must be aware of that decision, Mr. Chatterjee. Please show me that
But
decision.
today I have not brought that, Milord, but this decision, Milord, I rely upon even the Howrah municipal building rules also, because this is an area in Howrah, under Howrah, and
Yes.
the Panchayat Act also.
Have you taken, Mr. Chatterjee, to bring the present condition of the suit property before the learned trial judge?
Yes, Milord, there was a advocate commissioner appointed,
That was,
Milord, and yes,
that was earlier. After
yes.
whether one wall, whether it can be reconstructed or can
No,
be.
that is admitted in the written objection also. Milord, the other side says, Milord, the wall has fallen down, but they have also taken a plea, this is the reconstruction.
Mr. Chatterjee, it's within the municipal area.
No, Milord, this is Panchayat area. Amta Howrah is Panchayat area. Milord,
Yes.
under the Panchayat laws also, Milord.
What is the suit for?
The suit for eviction, Milord.
Under the Transfer of Property Act.
No, Milord, this is, just a second, I'll just check. The plaint is annexed at page 15. Milord, MNOP is the ground, Milord, under Transfer of Property Act.
Yes. See, if that is the ground, Mr. Chatterjee, it's difficult to allow you to repairs.
The court has allowed the repair.
Yes, evidence will be vanished then.
No, Milord, court has taken the note of the commissioner's report.
Mr. Chatterjee, it's difficult. If you move MOP is the ground, it's difficult.
No, Milord, kindly seeks the, Milord, kindly takes up the commissioner's report. But I say, Milord, kindly takes up the commissioner's report by virtue of which court allowed.
Mr. Chatterjee, their case will be strengthened if you are allowed to reconstruct.
But that's why I say, Milord, I take this, Milord, help of those, Milord, decisions where says, while repairing even due to rainfall, if there is a fallen bricks are falling down, Milord, that will, Milord, protect the tenement rather than, Milord, it will be considered to be a reconstruction.
Have you brought those line of decisions where what is permanent construction starting from 64 Calcutta, full bench decision?
No, Milord, I have not brought that, Milord. I can rely upon because the question of
construction, it will be you can be allowed to make that.
No, Milord, if there is no change of, Milord, nature and character of the suit property, Milord, all the Supreme Courts and all our high courts, Milord, have decided if there is no change, Milord, if a wall, Milord, standing straight up to 4 feet.
How can that be decided now? Existence of the wall now.
No, Milord, that is there in, that's why I said in the commissioner's report, there is there. Milord, a thorough commissioner's report is before the court. A thorough commissioner's report.
By the order impugned, the application for reconstruction stood rejected. Mr. Chatterjee, learned advocate appearing for the petitioner, submits that while undertaking the repairing work, the one of the wall on the northern side.
Yes, Milord, wall on the northern Uttar Dike.
The northern side wall of the suit property got had completely fallen down, and for which the reconstruction is necessary. First, a petitioner is directed to serve a copy of this application by register speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter under the heading contested application after 12 weeks. First up, it is however made clear that pendency of this application shall not preclude the learned trial judge from proceeding with the hearing of the suit.
Milord, may I just pray for one thing, Milord? This is Howrah Amta, Milord. May I come back earlier?
Yes,
Milord,
yes.
Howrah.
Call the next matter.
Item number 12.
Lordship, an application for expeditious disposal, Lordship.
Expeditious disposal of what?
Ejectment suit pending since 2006. Before the court.
What is pending?
Ejectment suit. Lordship, W has filed.
What happened yesterday? 22nd of July?
Lordship, 7-3 hearing was done, Lordship.
Yes.
7-3 hearing was done.
7th hearing was done.
Yes, Lordship.
Completed.
Yes, Lordship. Yes, Lordship.
This application under Article
wife petitioner before your lordship, a suit filed by the husband. There's an alimony application, penalty application, which was disposed of earlier, my lord, where, my lord, that the trial court has pleased to award rupees 50,000, considering the affidavit of asset, rupees 50,000 in favor of the wife, and my lord, litigation cost. This order was being challenged by the husband before this honorable court. Honorable coordinate bench was pleased to direct for rehearing of that alimony application. My lord, then this order is come out as 50% of the earlier order has been awarded. Though the factum is no change, the liability, rather the liability is lesser. Whatever the husband,
Affidavit of assets and liabilities.
yes, my affidavit that and the husband's is 33 to 141. And my lord, the second affidavit asset, which is, my lord, apologize me for, my lord, this is not annexed here, my lord. During this this second affidavit asset filed by the husband. And page 161 is the last order passed by the learned court below. Husband affidavit asset is 133 to 141. Not filed in terms of the guideline of the my lord, residence.
What is your source of income?
Nothing, Mala. I'm dependent upon the upon the husband. I was, but I have to complete the job after
179, your income tax return.
Yes.
What is the source of your total income?
29,000 from what?
179.
Yes, yes.
Kindly come to page 179.
Fine.
What is the source of your total income? Show me that you have disclosed in your affidavit of assets and liabilities.
It I mean disclose courage. 179.
Yes.
Page.
What is your name? What is your name?
Depositor. Depositor.
Yes. It's your income tax return.
179.
Yes.
My lord. Yes. Could take upon income tax.
Show me that.
My lord. একটুখানি কম কথা বলবেন, যেটুকু জিজ্ঞেস করছি সেটুকু বলুন। আপনি লিখেছেন এখানে দেখুন অ্যাসেটে আপনার ডিভিডেন্ড থেকে যে পান, ইনকাম ট্যাক্সের ফাইলটা দেওয়া আছে, ওটা না, এখানে লিখেছেন এফিডেভিট অ্যাসেট।
Income.
কোথায় কোথায় কোথায়? My lord, 116 page 41. Trying trading share market individual. And income from other sources, my lord, page 117, column 43.
43.
Column 43, page 117.
So,
interest on bank deposit by FDS and interest on investment, security, etc., etc.
So that is
Yes.
50,000 and 3,000.
Yes.
63,000.
Yes.
But in the income tax return, you have shown only 29,000.
Yes, because my lord, this is the calculation by the my lord, that can be been explained after consulting my আপনি কেন দিয়েছেন এখানে দাঁড়িয়ে এখানে আপনার দেখাচ্ছেন 53 আর এখানে দাঁড়িয়ে আপনার ইনকামে দাঁড়িয়ে জায়গাটা যে আছে কম কেন দেখাইছে was an investment and my lord 3,000
What is the source of your income that you could invest? That I was serving. Where you were serving?
I was serving TCS. That has been mentioned.
Yes.
I was service, but after one of the married, I have to completely leave the job. I have that document. And that has been dealt by the learned court below.
Is 178 bank statement, rupees
178.
10,000 credit. What's the source of that? Page
But that
178.
is from the that is from that the dividend and others. This is trading. So it's a market risk. This can be done only. That is the that.
Can you show me your statement of total income? How have you arrived at this figure of income?
My lord, I have bench. My lord, I have the bank statement. I have ended.
So bank statement you have ended. This is only
the details.
Sheet in the income tax return. That the total income.
This is the
Can you
income.
show me the calculation.
Yes, একটু দাঁড়ান দাঁড়ান complete. This is the return file.
Yes, yes.
My lord, for that is
the annexures to the income.
That is the share. That is the expenditure.
Yes.
That should be এনেছেন কি ওটা কম্পিউটেশনটা এনেছেন my lord, that's I have to submit.
All right.
I have that with me. I have to submit what as present. My lord, kindly
Some argument the learned advocate appeal.
when I will come tomorrow.
In the next week. This matter in the next week. Another hearing motion. Yes, next.
Item 10, my lord, was pleased to pass over, my lord. But I have taken instruction on my lord, the case status, the CNR number matches 11th of August for further argument.
For further argument.
As it is shown.
ওই ফাইলটা দিন তো যেটা পাসওয়ার্ড করে but
Sixteen, my lord,
yes.
16, my lord, I am appealing for the plaintiff petitioner.
Yes.
The suit for declaration of title and permanent injunction. In such a suit, my lord, an application for local investigation was filed by the defendant. May I draw your lordship attention to the
Defendant. You are the defendant.
I am the plaintiff.
Yes. Defendant's local investigation allowed.
Allowed. At allowed one, can you consider how it was allowed? Can you turn to page 17B, Annexure B? Local investigation, my lord, will find.
Defendant filed the application for local investigation.
Yes. And the court proceeded as if this is a local investigation, application filed by the plaintiff. That is why page 17, my lord, can you turn to page 17?
Page 17.
Yes. Application date 13 November 2024.
Yes.
দরখাস্তকারী একতে 5 নম্বর বিবাদী পক্ষে নিবেদন এই যে মানে got it?
Yes, yes.
Local investigation straightforward and
but it has been recorded at learned advocate for the plaintiff's group the petition dated 13th of November 2024.
Total, if I say it is not application of mine, something else, and what more I can say? Page 19, the objection filed by the plaintiff. Now, during pendency of the absent application, local inspection was filed by the defendant. That is page 21, dated first.
Local inspection was filed by the defendant.
Yes. 1st March 2025.
1st March 2025, yes.
Page 21.
Yes, that was rejected.
That was rejected and earlier was allowed.
One is local inspection. That is
what is local investigation?
We agreed by that.
I am agreed with the allowing that application. I am the plaintiff.
Rejection of local inspection, you cannot.
No. Only for
allowing the local investigation.
For declaration permanent injunction, there is no dispute for the purpose of ascertaining any schedule, and the court proceedings.
The difficulty, Mr. Rai, only it will be investigated. The investigation commission.
Another 8 years. Another 8 years.
Expediting that, I am fixing the time.
But if the court applies his mind in such a manner, if you logically consider, the learned tribunal is not in a position to understand what is for whom this application has been filed, what is the nature of this application.
16th of July investigation report. Report must have been submitted by in the meeting.
Otherwise, I will not before your lordship. Otherwise, I will not before your lordship in that manner. And the plaintiff myself for declaration injunction, and it is the I am objecting the same, and the court proceeded as is my application allowed the same.
There is substance in the argument made by made
For 17. I am for the petitioner.
Yes.
Plaintiff is the petitioner before your lordship. Lord, if my lord kindly once looks at page 14, I will not read the prayer, my lord. Your lordship kindly looks at page 14, the prayer made in the plaint.
লাইভ স্ট্রিমিংটা বন্ধ করতে হবে।
Matter number 18, I am for the petitioner, but my lord had appeared on behalf of the petitioner, my lord. My lord may come to page 110, my lord, the order.
110, you have annexed the order.
My lord. That is a part of the annexure, my lord.
Ashun.
17, I am for the cavator, no copy has been given. Just now I have looked the matter. 17. No copy has been given.
Yes, Mr. Mukherjee, take 17 ta din.
Oh, that's sure.
Matter number 19. 19, well, I am Subhash Shah, but I am not placing this application. I am
The learned advocate appearing for the petitioner. Ashun, the learned. Yes.
My lord, I am defended petitioner before your lordship. My lord, suit for declaration and my lord, plaintiff filed application order 39, rule 1 and 2.
Yes.
And my lord, defendant number 2 and 3 filed written objection against this
Yes,
application.
injunction application has been fixed on 19th of November.
Yes, my lord.
What do you want? Expeditious hearing?
স্যার আমার একটু বলার আছে কিছু। স্যার আমি এটা কালকে দেখতে পেয়েছি, তো স্যার এইটাতে আপনি এর আগে একবার অর্ডার দিয়েছিলেন।
Order দিয়েছিলাম।
Your lordship directed for expeditious disposal order 39 rule 4. Now order 39 rule 4 court says that as there is no misrepresentation, therefore that has been turned down.
Yes.
Now my order 39 rule 1 to ready for hearing, next date has been given.
Order 39 rule 1 and 2 আপনার অ্যাপ্লিকেশন তো
না আমি ওপি 1
plaintiff
তো আপনার অ্যাপ্লিকেশন নিচের কোর্টে আপনি তো ওটা তাড়াতাড়ি শুনানি চান
না আমার তো
চান না
3 তারিখ চাইলে অসুবিধা নেই আবার স্যার অলরেডি একটা শুনানি হয়েছে
kindly record that
আমার স্যার অলরেডি একটা শুনানি হয়েছে এপ্রিল মাসে এবং সেটার অর্ডার স্যার আপনি দিয়েছিলেন যে এটাকে ফার্স্ট অর্ডার করার জন্য 39 রুল 4 স্যার রিজেক্ট হয়েছে বোথ পার্টিজ এর হিয়ারিং এর পর এবার স্যার আমাদের স্যার মানে আর্জেন্সি এই মুহূর্তে স্যার কোনো এক্সপেডিশন হয়নি যে এটাতে স্যার আবার এগোনোর জন্য মানে আমার বাবা স্যার শরীর খারাপ ওখানে স্যার
না এগোচ্ছি না 19 তারিখে তো 19 নভেম্বর দিন ফিক্সড আছে আমি ওই দিনে আমি এগোচ্ছি না
kindly visualize my kindly see the contention we don't want
marriage in 2011, the match suit filed under Special Marriage Act in the 2022. After 8 months, the husband respondent files the WS, Millard. Till date, Millard, the court was vacant. Several adjournments has been taken.
Now the court is present or
No,
wait,
Millard.
then what can be done? Suit cannot be executed.
Next date is on September, 12th September.
The regular court is not present, what can be done?
My lord, they can assign to Millard any other court, Millard. No, Millard, 11th court is present, Millard. It has been transferred to 11th ADJ. The last order number 70. The court is present.
Any alimony application has been filed?
No, Millard.
You are the husband.
I'm the wife.
You are the wife. This application under Article 227 of the Constitution of India Yes, Mr. Ghosh.
Lord, the petition of Lordship are defendant in a suit for declaration and injunction.
There is a caveat. I'm coming after 5 minutes.
Yes.
behalf of them, Lord, the defendant petitioners before your Lordship.
Yes.
So initially suit was filed for declaration that the plaintiffs opposite parties have 7/8 share in the property and injunction.
Not partition.
Not partition. Well, and the trial court refused injunction. Thereafter, appellate court granted order of status. We challenge that order. The honorable court said that suit is not maintainable. Therefore, injunction was vacated. However, they were given liberty to make appropriate application for amendment. Application for amendment was filed, but that was rejected, and it was upheld by the honorable court because they stated that in terms of the honorable court's order, we are making this application for amendment. However, my lord, ultimately, the second time also, the coordinate bench directed that they may make an amendment adding a prayer for partition. What happened, my lord? Kindly see the nature of the suit. We made an application on Order 7 Rule 11.
So now what happened? They have filed an application for partition.
Partition.
That has been allowed.
Allowed. Lord, kindly see, Lord, that civil court has no jurisdiction.
Why?
At all. Because, Lord, their own case is that it has been purchased in the name of the petitioners. That is a Benami. Your Lordship, kindly see the pair of the plaint, two paragraphs, your Lordship, kindly read. Lord, page 28. Your Lordship, kindly come to page 28 plaint. Lord, page 29. 1, 2, and 3 paragraphs, kindly read, Lord, thereafter, Lord. নিম্নে তফসিল বর্ণিত সম্মতি কতকাংশ বাদীগণের ও 1 নম্বর বিবাদীর পিতামাতার সত্ত্ব দখলী সম্পত্তি থাকা অবস্থায় মৃত্যুমুখে পতিত হলে বাদীগণ 1 নম্বর প্রতিবাদী ও তার পুত্র কোন তুল্যাংশে নিম্ন তফসিল সম্পত্তি প্রাপ্ত হইয়া এলার সেটেলমেন্টে নিজ নিজ অংশমতো রেকর্ড করা সত্যবান মতো দখলীকার হয় না। নিম্নের তফসিল বর্ণিত সম্পত্তি সমূহ বাদীগণের ও 1 নম্বর প্রতিবাদীর পিতামাতা তাদের পূর্বপরিচিত মহাজন জনৈক মেথর চন্দ্র নন্দী মহাশয়ের নিকট ফেরত পাইবার চুক্তিতে 1967 সালে 57 নম্বর অষ্টম আকারের বিক্রয় কোয়ালা দলিল মূলে বন্ধক দেন। মহাজন উক্ত মেথরচন্দ্র নন্দী নিম্নের তফসিল বর্ণিত সমূহ বন্ধক মুক্তি অর্থাৎ ফেরতের জন্য বাদীগণের ও 1 নম্বর প্রতিবাদীর মাতা পিতাকে চাপ দিতে থাকিলে বাদীগণের ও 1 নম্বর প্রতিবাদীর মাতা পিতা নিরুপায় হইয়া তৎকালে একমাত্র বিবাহযোগ্য জ্যেষ্ঠ পুত্র 1 নম্বর প্রতিবাদীর সহিত 2 নম্বর প্রতিবাদীর বিবাহের চুক্তি করিয়া বর্পণ লইয়া প্রতিবাদীদের নামে নিম্নের তফসিলবর্ণিত সম্পত্তি গোঘাট সাব রেজিস্ট্রি অফিসে 71 সালে ফেরত কোয়ালা দলিল মূলে ফেরত করিয়া লয়েন। যেহেতু 1 নম্বর প্রতিবাদীর বর্পণ নিম্নের তফসিল সম্পত্তি পক্ষগণের পিতামাতা ফেরত নেন, সেহেতু পক্ষগণের পিতামাতা 1-2 নম্বর প্রতিবাদীর অষ্টম সিভিল আকারে বিক্রয় দলিল করিয়া রাখেন। পক্ষগণের পিতামাতা পরবর্তীকালে 1 নম্বর প্রতিবাদীর বিবাহের যৌতুক হিসাবে 4034 টাকা 1-2 নম্বর প্রতিবাদীকে ফেরত দেন। প্রকৃতপক্ষে 1-2 নম্বর প্রতিবাদী পূর্বতন মহাজন মেথরচন্দ্র নন্দীর স্থলে নতুন মর্টগেজের পোস্ট হোল্ড করা থাকা অবস্থায় বাদীগণ 1 নম্বর প্রতিবাদীর পিতামাতা মর্টগেজ মানি মাই সুদ প্রতিবাদীকে আদায় দিয়েছেন, কিন্তু ক্লোজ রিলেশন থাকায় কোনো কাগজপত্র তৈরি হয়। Now, my lord, kindly see what is the deed. Deed was executed by the mortgagor. He took the money from the father-in-law of the petitioner number 1 and father of the petitioner number 2. There, in this recital of the deed, it has said that the opposite petitioner number 1 and 2, they will be life estate holder, and ultimately the property will go to their siblings. Absolutely. This is the recital of the deed, and Lord, they have claimed that it has been purchased in the name of the petition number 1 and 2 and sought for such declaration. Lord, your Lordship knows, Lord, Section 45 of the Benami Section Prohibition Act, civil court's jurisdiction has been expressly taken away. Therefore, we made an application under Order 7 Rule 11 that this court has no jurisdiction at all. Therefore, question of amendment, and if Lord,
7 Rule 11 rejected.
Yes, that application has been rejected, and Lord, amendment has been allowed.
No, amendment was allowed earlier. Thereafter, Order 7 Rule 11 has been rejected.
Same on
but
by
Order 7 Rule 11, no reasons have been assigned.
No, by the same order.
Milord, since Milord, by virtue of the amendment, Milord, the jurisdiction of the court, Milord, will go out. The court says, Milord, he will be at liberty to file the Order 7 Rule 11 afresh after the plaintiff is returned and file it before the appropriate court.
But Milord, if this
let me go through.
Yes.
Yes, Mr. Ghosh, you can file your order 7 rule 11 before the appropriate.
Lord, your lordship, my case at the threshold. If the civil court has no jurisdiction at all, the question of amendment, everything goes.
But you have not read
But it is not
at the time of amendment.
Yes. No, your lordship, can you see that they are not made any amendment?
In the amendment, show me his application for amendment.
Yes.
So amendment is only incorporating the prayer for partition, nothing more. But in the original suit
is goes.
So that is order 7 rule 11. So now that remains, whatever defect is there, that remains.
Lord,
so you can file.
Lord, that I appreciate. But Lord, if you think that the civil court has no jurisdiction to entertain the suit itself,
yes,
on the basis of Benami.
I appreciate that. So you take that point. I will
have taken that point specifically by making the application. This court has no jurisdiction. Lord, if the question or amendment relating to that point, I had nothing to say because they have
partition only has been
they have amended.
Now you say that the suit itself, even if the partition is allowed, even then the suit is barred in view of the Benami Transaction and Prohibition Act. So if that is so, order 7 level is there. So now it has been rejected, but once it is filed before the appropriate court, I am giving you liberty to take out an application. All points will be kept open.
Lord, that I know. But Lord, your lordship think, Lord, if the particular court has no jurisdiction to entertain a civil suit, then Lord, if that is the amendment, subject matter of amendment is that part, then I had nothing to do that. They have amended and withdrawn.
What is your application for order 7 rule 11?
Lord, your lordship, can you see that has been annexed? Yeah, I am giving the page. Application for order 7 rule 11, page 55.
Show me, Mr. Ghosh, show me the earlier order passed by this court.
My lord, your lordship. That is Lord Justice Basu. That page 49. 47 starts 49. Thereafter, we made an application first.
But Mr. Ghosh, that's the problem. Now, I cannot say anything now because only this liberty was given.
Liberty was given, Lord, that amendment was also.
So, pursuant to that, the learned trial court also could not have gone beyond that. That's the difficulty. You
That,
could have raised,
that amendment application was rejected after Justice Basu's direction.
yes, thereafter,
Another application was made.
yes, that was also rejected.
Before that, we have made an application under Order 7 Rule 11, pointing out that this court has no jurisdiction, the civil court has no jurisdiction. If the jurisdiction was not there, he cannot do anything, Lord.
No, please kindly come to the order in CO 1231.
Yes.
1231.
Page 65.
Yes, page 65. So it says the court has observed that if the prayer for amendment by introduction and the valuation exceeded, if the court would return. So this is the direction.
And before that, Lord,
So please kindly come to the page 64.
Yes.
That order does not find it necessary to interfere with the order impugned, as it appears that the amendment in paragraph 3 of the schedule was introduction of a statement in terms of such and such that the plaintiffs and a preliminary decree to that effect. While incorporating such prayer for a preliminary decree, the other prayers were deleted. Such amendment is contrary to the plaint case, contrary to the order, and thus makes the plaint itself defective. The court had rightly observed that if the prayer for amendment by introduction of the relief, so the nature of amendment is misconceived under such disposal by giving liberty to for incorporating the addition, because this, Mr. Ghosh, this the High Court has given them liberty.
Yes.
So now I cannot appeal over that. So now the amendment has been, I am giving you liberty, you can file, because you did not take that point. You are there, Mr. Ghosh. You did not take that point. Even that point cannot be raised.
That point was raised, Lord, and you can kindly see when the application for under Order 7 Rule 11 was filed.
I appreciate that, but in the High Court's order, nothing has been reflected with regard to that.
Lord,
That's the difficulty.
Lord, that
Now I cannot say that.
Annexed with the divisional application Order 7 Rule 11.
I appreciate that, but
that has not been.
That has not been so. So only the High Court gave liberty. So how can it sit in appeal over that?
Not gave liberty, that is all right.
So,
but Lord, if the court itself lacks jurisdiction to entertain a suit itself.
Mr. Ghosh, I appreciate that. But please kindly come to the direction. Gave liberty to and further steps in accordance with law. Paragraph page 65. Because
page 65, paragraph 4.
Mr. Ghosh, what happened? Initially, Justice Basu passed an order.
Yes.
Justice Basu said No, so the suit is barred in view of the absence of the relief for partition.
Yes.
Now they went back. They filed an application. So there was also liberty granted in Justice Basu's order, page 49.
Yes.
So that was there. Now thereafter they went back.
They went back and
They
filed
went back.
application for amendment.
Yes, they filed an application for amendment incorporating the prayer for partition and they sought to delete some other portions.
Yes.
The learned trial judge rejected. Then they came up before this court.
Yes.
Justice Sarkar said, no, you could not have deleted because you could have incorporated that prayer. So that is against the direction of the High Court. So that was said that yes, I am not interfering with that. Gave liberty to file an application. After that, and Justice Sarkar also made it clear that if it
Lord, I have
exceeds,
as felt from my lordship, it is
the only difficulty. Otherwise,
right.
Mr. Ghosh, I am with you that while considering an application under Order 6, Rule 17, if it is barred, it cannot be allowed. If the suit is itself barred, amendment cannot be allowed. Look, I'm fully with you, but with in these two orders, they have been given liberty to file an
let them do it, Lord. But what will be amended? This who will decide it? When the civil court itself lacks jurisdiction, jurisdiction has been expressly taken by Section 45 of the Benami Transaction Prohibition Act. Expressly taken. Suit is not there. How amendment would be allowed? How my application can be rejected?
Taken that point in the earlier round of.
No, I have taken. Not that very question. This has not been dealt with.
Then
whatever it was, the application was filed under Order 711.
Justice Basu, you
after Justice Basu's order.
No, before Justice Basu, you are there. No, you are not. Yes.
No.
Justice Basu also you are there.
No, at the relevant time it was filed.
Oh, thereafter you filed.
After Basu's order you filed. Therefore, if it appears,
do you have a copy of the Benami Transaction Act?
Yes.
That is the difficulty which I am.
Lord, if the civil court lacks jurisdiction, how? Nothing can be done. Suit itself cannot be entertained. Or modification, this should be transferred to the competent authority.
Section
45.
Oh, Mr. Ghosh, is it the new amended act?
Yes, I have.
Amended act.
Lord, amended act section 16 of the Amendment Act. In 2016, it has been amended.
Yes, 2016. So this is section 45, you said.
Yes. Expressly, civil court jurisdiction has been taken away. And clear case of Benami transaction. Admittedly in the plaint. Nothing can be done. Even no jurisdiction or civil court's jurisdiction is taken away.
Yes, sir. What do you say to this? If the court lacks jurisdiction to decide a suit, could not have allowed the application for amendment.
Subject to correction, my lord, the High Court, my lord, has specifically directed, allow me to, my lord, incorporate that prayer. By the Justice
Gave liberty to file an application for incorporation.
Yes,
that does not mean. So there are two things. One is the High Court was of the view that the suit was barred in view of Section 34. The prayer for partition was not there. Gave you liberty. Now the question remains, while considering an application for amendment, the question whether that proposed amendment is barred or not has to be looked into. Now, if the suit is not maintainable before the civil court, whether an application for amendment can be allowed. What do you say to this?
My contention subject to.
Are you ready with this matter? Or if you want, I can give you time because it's.
Will come back with regard to this, my lord.
Because Mr. Ghosh has some point, because only difficulty is that there are two coordinate bench decisions directing. That's the real problem.
But that give the jurisdiction to the civil court.
That is
because the statute bars.
So if the suit is barred, what will be the use in amending? And even that cannot be before the civil court. Because this return of plaint was to be filed before the court having pecuniary civil court. It could not have been. It could not have been done. So it will be a futile exercise. One thing is that you can file before the proper court. Mr. Ghosh can be given a liberty. He will again file an application, another round of litigation.
Yes.
Unnecessary.
That is what, my lord, the learned.
But it is unnecessary. It might be unnecessary. Yes. If the courts do not have jurisdiction, why burdening the court with another suit to be filed, again another application,
another round of
a series of litigation?
Then I'll come back with this. My lord.
Have you filed the suit?
My lord,
No,
the
not
date
yet.
is fixed for my lord filing of the.
When?
It is my lord fixed on.
30th of June
My lord.
for filing the amended plaint. No, this is
No,
returned.
not yet.
Oh, proper court with the amended plaint. 30th of June, why did you
My lord,
have not filed?
My lord, I think I have filed. I have a document,
No.
my lord, that is amended.
That is filed in that court.
Filed where?
Before, my lord, this amended plaint was filed before, my lord, the civil judge junior division.
Could not have been filed.
Yes.
Could not have been filed in view of this direction.
My lord,
Shall be left with no alternative but to approach the proper court before which the amended plaint shall be filed after return of the plaint in
yes,
accordance.
my lord, the last or line in the order fixed 36 for filing amended plaint positively and for passing further orders regarding return of
Further order.
So, my lord,
That is
it was
return of
directed
plaint
to
order has
file before
not
this.
yet been passed, my lord, under section
So
10.
you have filed. So you have complied with that.
Order 10, order 7 rule 10A has not yet
So I
been,
will
no
hear
order has been
this.
passed.
I'm staying that
Yes.
all further proceedings of that.
My lord.
My lord, I can come back next week, my lord, with your lordship. I can come back next week, my lord, if you
Whatever it
The
is.
point which is to be decided. It has to be hard. So, Ashun. Mr. Ghosh, forum has been constituted for deciding this.
Appellate authority also.
Appellate authority has also been constituted. What's the forum? Where is the forum? Income tax
Yes.
department.
Yes, ठीक है. Lord, I think.
Where is the forum?
Additional.
Where is the appropriate authority?
Lord, appropriate authority. Section. What is that? Section 18.
No, appropriate authority has been defined, I think. Yes,
Yes.
please. Section 2.
Section 2.
Adjudicate authority means
Yes, adjudicating authority.
appointed under section 7. Here this is only this.
Yes, section 7.
Section 7. Appointed under section 7.
Section 7 appointment has been made.
Well, I think
because I was hearing a matter in the division bench on this, decided over by Justice Tandon. I think Mr. Ghosh was appearing in that matter. Mr. Bhaskar Ghosh was appearing in that matter.
It was similar.
On this issue. At that point of time, I think that authority was not.
And provision of transfer is also there. If pending, it should be transferred.
Pending proceedings should be transferred.
Except before the Honorable Apex Court or before the High Court.
Here in this case, suit filed when?
2020.
2020. Yes. And when this amendment came, that's prior.
Prior.
But the suit can be transferred.
Yes.
Suit can be transferred
to the authority.
But the question is, Mr. Ghosh, whether this partition and other things can be decided.
My impression was, Lord, authority has been constituted. I shall come back with the Lord, definitive instruction.
Yes, IRS. Members of the IRS, section 9, that will be the qualification of those.
Yes.
Well, partition and other things will be decided by that authority. But Mr. Ghosh, these points were not decided. I think it's better if you flesh out there, because it requires a consideration of this. Because if in this civil division it is being made, it is very difficult, because these points were not argued. Now, for the first time, nobody will have an appellate forum against this. If the plaintiff is rejected, let us assume plaintiff is rejected, so there will be no appeal. Please consider the judgment delivered by Justice Bakshi on this.
Yes, right.
Recent decision which says should not be done in 227. Rejection. If that is so, you can take, I can give you all points kept open, you take it there. So then one way or the other, you will be having a right of appeal also. Please consider the judgment of Justice Bakshi on this, whether the 227 for the first time plaint can be rejected. Yes, next.
Section 23. Plan for the petition. But by virtue of the order impugned, the application for modification of the injunction order is being allowed. It's order 43 Rule 1R. But only one thing, the order date is 2nd of July 2025, and the forum is also since the valuation of the suit is 5 lakh, so it will lie before this honorable court itself. If your lordship kindly direct the department to convert it.
Mr. Mukherjee, it's difficult because it's a composite application. Now you have to file a memorandum containing the grounds. You have to file a stay application. So it's difficult. Withdraw other because it will be difficult, because would have been considered, because you have to file a memorandum. So treating these grounds as memorandum, other parts, it's Mr. Mukherjee, learned advocate, appearing.
Passed under section 24,
by which my wife has been granted alimony on the ground that there has been suppression of material facts by my wife, and my contentions in my written objection has not been properly considered, my lord. In this case, my lord,
10,000.
10,000, my lord. I was running a clinic that had to be closed down because of my wife.
Why?
My lord will kindly come to my written objection. Starts at page 24, but my lord will kindly
What
come.
are you doing?
I am a dentist, but my clinic which I was running had to be shut down. Had to be shut down because my lord will kindly come.
Now you are not doing anything.
If my clinic is shut down, what will I do, my lord? If my clinic is shut down, my lord, that is the problem.
How are you maintaining yourself?
That with the past savings, that is what
savings.
That is what
That also has to be considered for the purpose of paying alimony.
But there has been
That is
suppression
the
of
law
material
now.
facts.
Past savings, your other income, property.
My wife is admittedly earning a sum of rupees.
Admittedly, show me the admission.
My will kindly come to.
Show me the admission made by the wife that she is
page 50, my lord. She has deposited and is an unconnected proceedings that she is working.
She is working or was working?
She at that relevant point of time was working.
Yes.
No, I have the page.
The same.
I have the pay slip, my lord. I have a pay slip of May 2025.
Both of you are on the same footing. You are also previously earning, not earning. She was also previously earning, not earning now.
May 2025, she has drawn salary. She has deposed in.
Show me that how that fact was considered by the learned trial judge.
And I'll just show her admission first. Page 50, my lord. This is January 2025. This is not very long ago.
Page 50. Yes.
This is a deposition of an unconnected proceedings. Antara Shaha Shantra. This is my wife, and my lord will kindly come to the fourth line of the deposition. Third line, last word, my lord. I was during that time working as a security guard at Veterinary Girls Hostel at Khudiram Bose Soroni.
Yes.
This is
at
a
that point of time. So in 2022.
In 2022, but she has not
The deposition is in 2025, but it relates to a fact of 2022.
I'm led by.
Kindly, my lord, see the bills, pay slips. So did you produce it before the learned trial judge? My lord, don't hand over any document which were not produced before the learned trial judge. My lord, kindly see one thing, my lord. Kindly see one. Show me from the materials which were on record before the learned trial judge. My lord, false deposition has been made by the wife. Take steps in accordance with law. My lord, thereafter, my lord, kindly see the order impugned. My lord, we have, my lord, I have given the, my lord, page 2. My lord, kindly see internal page 2 of the impugned order. Last but, my lord, 3 paragraphs above. It is also stated by him, my lord, the husband. Page 2. Page 2. Internal page 2 of the. Yes. Which line? My lord, third paragraph from the, my lord, bottom. It will be stated by the husband. Yes, I've got. It is also stated by him that the petitioner is working at Bengal Veterinary College, and she has sufficient income to maintain herself. Well, there is a, my lord, I have taken this specific point in my written objection also. My lord, learned court below, my lord, this ignorance, my lord, passed the award of interim maintenance of 10,000. My lord, we are both a divorcee. My lord, she has, my lord, earlier one son. My lord, they are, my lord, one after another litigations have been, my lord, against me. My lord, my humble submission, my lord, let her come before your lordship, and my lord, will, my lord, place this, my lord, payslip whether this is or not. She is a working lady, and false deposition in the assets also. Declaration of assets.
Well, the submission also presently she is unemployed. Well, another thing, my lord, I would like to show before your lordship. My lord, কোনটা গো? না না ফলস যেটা ক্রিমিনাল কেসটা তো কত সালে
দেখিয়েছি
আচ্ছা মানে deposition was made on 27 January 2025. At that point, কিন্তু deposition was made on 25th, 27 January. Yes. My humble submission, my lord, copy be served, my lord, kindly direction. Let him, my lord, come before your lordship. My lord, disclose her, my lord, whereabouts. Whereabouts? My lord, whereabouts means, my lord, the income, in regard to the income. That is my humble.
Where is your affidavit of assets and liabilities?
My lord, affidavit of assets, my lord, page 31. My lord, and page 31 is the, my lord, first page. Well, this is the husband's asset.
Husbands you have not annexed.
My lord,
You have annexed the affidavit of assets and liabilities of the wife, not the husband.
my lord, this is wife, my lord. I have annexed.
Husbands you have not annexed. Your client's affidavit you have not annexed.
Can you put it? Yes. My lord, front page, my lord, kindly see the professional qualification, no. My lord, occupation, no. Monthly income, no. Page 31.
So what type of an affidavit of assets and liabilities you have filed? Everything is blank. Nothing, you have not disclosed anything. Total suppression of facts. Total suppression. That is why you have not annexed this affidavit. Nothing you have stated. All columns are blank. Only those relating to the spouse you have filled it.
Well, she has also, my lord, declared.
Yes,
my
yes.
lord.
From page 3, none of the columns are filled up.
Can you annex position?
And you have also suppressed bank accounts, everything you have not disclosed. Yes, anything?
Paragraph 11, I have stated, my lord.
What paragraph? Relative to assets and liabilities.
Yes.
Nothing.
Yes.
You have not disclosed. Ashok, this application
of the amount, my lord. Kind
10,000 dentist, you should have volunteered.
She is also independent income, my lord. She has also independent income. Kindly, my lord, some.
So, even then, my lord, 10,000 is on a lower side. And considering your affidavit of assets and
My lord,
liability,
I leave it to your lordship, my lord. That
you have
I
suppressed everything. This shows that you have income.
am grateful to lordship.
Lord, the order number 50, dated 20th June 2025 is the supplement of civil revisional application, my lord. The petitioner is a complainant.
This order is an appellable order. District Commission's order is an appellable order before the State Commission. Why 227?
My lord, still, my lord, your lordship have the superintending. My lord, then
Supreme Court has deprecated.
my lord, then, my lord, kindly, I have my one humble prayer, my lord. If the entire complaint application can be, if the learned forum can be directed expeditious disposal of the case. As because, my lord,
This District Commission, that can be done.
yes, my lord, because the case was registered in the year of 2024 and still it is.
You are the complainant.
I am the complainant, my lord.
After some argument, the learned at this application under Article 227 of the Constitution of India is at the instance of the complainant and is directed against an order being number 14 dated 20th of June 2025 passed by the learned presiding officer, District Consumer Redressal Forum, Kolkata, in complaint case number 121 of 2024. First of all, after some argument, the learned advocate appearing for the petitioner prays that a direction be passed upon the learned District Commission to District Forum or Commission. Now it's not forum, it's commission.
District Commission.
ওটা ডিস্ট্রিক্ট ফোরাম যেটা বললাম কমিশন করে দেবে না ঠিক আছে কি বললাম এখন কি বলছিলাম passed upon the learned District Commission to
District
dispose of,
Consumer Dispute Redressal Forum.
not forum sir, now it's
Commission,
commission.
yes, commission.
Initially it was forum. কি বললাম direction be passed to dispose of the complaint case expeditiously. So in the light of the submissions made by the learned advocate
Within a period of 3 months.
CO number such and such stands disposed of by requesting the learned requesting
The learned District Consumer Dispute Redressal Unit
District
2.
Consumer Redressal Forum at Kolkata to make an endeavor to dispose of
Kolkata
the,
Unit 2,
consumer to dispose of the complaint case number
121 of
121 of 2024 as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Within a period of 3 months, my lord. My lord, it is.
Don't-
My lord, the
Don't
statute.
put undue pressure on the commission. Yes, next.
Item number 26.
I am on behalf of the petitioner.
Yes.
Matter is related to expeditious disposal of the suit, including the petition under Order 39, Rule 1 and 2 CPC pending since March 2024.
You are the defendant.
Petitioner.
No, no,
Plaintiff of
petitioner
the
is
suit.
plaintiff. This application under Article 227 of the Constitution of No, caveat has been lodged.
Caveat, but I have been instructed to appear, Your Lordship.
Mr. Ghosh, she has instructions to appear.
Yes, Lord, we shall give sub copy.
Can you not serve her a copy?
Copy.
What is the order?
Lord, eviction order under the Public Premises Unauthorized Occupants Act 71.
Lordship, this is
Yes.
Section 9 applicable.
LIC.
LIC.
Oh, you are LIC.
Against the appellate order. Against the appellate order.
Appellate order, final disposal or the interim order?
No, but this is disposed of. Final order.
Then this appeal is to be heard, Mr.
Your Lordship, kindly. Because Lord, the procedure has been followed by notice of eviction terminated the tenancy not on the basis of Section 4. A state officer under Section 4, Lord, will have a notice to show cause on such and such ground. After being satisfied or not dissatisfied with the notice, the proceeding would be proceeded with.
Here, any occupation charges we are directed to
Lord, directed occupation charges from the Lord 93 that has been set aside by the appellate court.
Yes,
Appellate from set aside.
Appellate court during the pendency of the appeal, you are directed to pay any occupation charges.
No.
6,73,000.
That is by the final order. No, any occupation charges was levied during the.
Lordship, occupation charges.
Lord, occupation charge, no, yes. 5,000 per month we have been paying.
5,000?
Yes.
What is the extent of occupation, Mr. Ghosh?
Lord, that is by the order passed by the estate officer.
Estate officer, so now.
Appellate authority.
Appellate authority.
Yes.
Now you have moved to the High Court, so it has to be enhanced, Mr. Ghosh. What's the area of occupation?
That is, Lord, 17.
Lordship, my lord gives me 2 days.
1,700.
Necessary instructions, Your Lordship. If my lord
Seven-
gives me 2 days time, I'll come up with necessary
1,700.
Instructions with regard to what?
instruction with regard to the occupation charges, instruction to the amount of areas, and instruction to the amount of what is the
Lord, the amounts of area as held by the estate officer has been set aside
whether
by point number 4 by the appellate authority.
But Mr. Ghosh, you have been directed to pay this amount, this area amount as per the appellate court's order. So you have to deposit that, Mr. Ghosh.
Lord, that amount, Your Lordship, kindly see, he has calculated.
Deposit that amount, Mr. Ghosh. Money decree, as you are well aware.
That I know, Lord.
You have to secure, not deposit, they will not get it.
This is occupational charge has been decided not unilaterally without giving an opportunity, without any evidence. This has been done.
The Ghosh, money decree, you
That we know, Lord. Kindly see how he has arrived at. And on the basis of that notice, by the lawyer's notice, not
the extent of your occupation. What are you doing? Commercially exploiting?
Yes, 1,700 square feet.
How much?
1,700 square.
What is the market rate of rent, Mr. Ghosh?
is Chittaranjan Your Lordship.
5,000, that was the reaction. Now what would be the?
Mr. Ghosh cannot now say 5,000.
No, I know.
Yes.
Lordship, the damages have been immense, Your Lordship. Around 57, more than 57 lakhs. And this is the damages and the occupation charges that has to be assessed of the prevailing rate of rent existing in the locality, Your Lordship. Since 1949, you are occupying.
1943, Lord.
But Mr. Ghosh, you are originally inducted or you have come in subsequently?
Lord, I am originally inducted by the company which was before taken over by the insurance company.
What's the ground of challenge in this civil?
Lord, here no kind of procedure is wrong. Totally. Section 4 notice instead of lawyer's notice proceeding has been started. Lord, your Lordship knows Section 4 state officer will issue notice specifying there in the ground and ask the.
Yes, madam, what is your instruction?
Lordship, I don't have.
Is it the lawyer's notice or the?
No, that is finding.
That is the finding.
Both the courts.
Lawyer's notice has to be given, Your Lordship. The show cause notice.
Lawyer's notice is a different thing altogether, but the proceedings cannot be initiated on the basis of the lawyer's.
I bow down. This is the procedure is like this, Your Lordship. 106, the quick notice has to be issued with the stipulated time.
That is the different thing.
Section show cause notice has to be issued.
Yes.
I have to look into the record what is there, but if my lord permits me, I can file an opposition also to that effect. And to that effect, Your Lordship, a week's time if my lord permits me, I'll come up with all the instructions as well as I can file necessary oppositions to bring all the records, whatever is not, I have missed out.
But what do you say with regard to the occupation charges? Because this has to be stayed, because otherwise it will become infructuous. So it has to be stayed.
Your Lordship, the damages which has been assessed by the estate officer, if my lord comes to page 5072 of the order of the estate officer, schedule 2.
Yes.
3% of this damages and the occupation charges, Your Lordship, it can be Chittaranjan Avenue 1700 square feet, Your Lordship. That
Yes, Mr. Ghosh, this amount you have to secure.
Lord,
what
we
you
have,
have-
we have been directed to deposit 20 lakhs.
I'm not directing you to pay it to them, but you have to secure this.
Lord, kindly, Lord.
You have to secure this, Mr. Ghosh. That's the law. If you want stay of this, you have to secure that.
The damage.
Lord, they are claiming 50%. I'm depositing 50% of the amount as directed. As directed, Lord, 50% we have deposited.
And the occupation charges, what would be the amount? When can you come back?
Lordship, tomorrow?
Because with regard to the occupation charges, because he has to take instructions.
Yes.
And Mr. Ghosh, what is your assessment with regard to the occupation charge?
Lord, I have not
Lordship,
given any. I have not given any instruction, but it is 5,000 is not fitting. 1,700 square feet. And one Chittaranjan Avenue, 15 feet. That is not.
Tomorrow.
So I'm making it not today only.
Lordship.
You have given a copy.
I will,
Yes.
Lordship, let
Okay.
one order.
When this matter is taken up for hearing, pay the occupation charge.
Yes.
So that subject to, yes, next.
Item
number 28. Yes.
Lordship, I appear for the petitioner in this case. Lordship, it's a suit for eviction. Lordship, there are two pending applications. One under Order 39 Rule 1 and 2 filed by me, whereas there are two applications under Section 7.1 and 7.2 of the West Bengal. Lordship, Lordship, if your Lordship sees the impugned orders, Lordship, the further dates have been fixed for hearing of
Petitioner's hearing.
Lordship, Lordship, no, Lordship, there's a catch to the Lordship. I want my application to be superseded in place instead of the applications preferred by the defendants in the suit. Lordship, if I may
What
just
is your application?
Lordship, my application is under Order 39 Rule 1 and 2, claiming injunction as to creating any as to commercial exploitation, as well as making changes, structural changes to the flats. Now, Lordship, what has happened, if your Lordship kindly sees the order sheets at page 92, Lordship, once. Lordship, you'll see on 24.
When is your application fixed?
Lordship, my application is not fixed. That's the thing. Lordship, 7.1, Lordship, my 7.1 and 7.2 application has been fixed for hearing. But if your Lordship sees, this application was filed on 13th March. If your Lordship kindly comes to page 92, Lordship, I'll just show the sequence of how the suit has been running, Lordship. Lordship, on 24 January, I filed my suit, and the next date fixed was 13 June.
So then you have to serve upon the other
Yes,
side.
Lordship, if I may just show like.
You have to direct because there is a date fixed for hearing of this 7.1 and 7.2 application.
Lordship,
if I say that no, not that application, your application, I'm directing you to serve upon the other side.
Lordship, I'll just throw one anomaly on the part of how the suit has been running, Lordship. Just once. Just
without their hearing them, how can this be done?
Very well.
I can give you liberty. You can make a prayer before the learned trial judge for fixing a date of your
Lordship, we've done that as well, which has went unheard. In that case, Lordship will kindly direct to serve. Lordship will kindly direct service, Lordship.
The learned advocate appearing for the petition.
My lord, I am for the petitioner, my lord, for expeditious hearing, my lord, matrimonial suit, my lord, suit filed for.
Who are you?
My lord, husband, my lord. Suit filed by husband, my lord, for divorce, my lord. Suit filed in the year 2013, my lord.
And
Only-
any alimony order has been passed?
My lord, now area amount due, my lord, about my lord 5 lakhs. My
Have
lord,
you
I
paid that?
My lord, I approached them, my lord. They not taking with the money, my lord. My instruction, my lord. The wife is for the timing living at Bombay, my lord. My lord, the learned lawyer not taking the my lord money, my lord. My lord, fixed before your lordship, my lord. I am ready to pay. Not giving the my lord bank account, my lord.
This application under Article 220 presiding officer is not here, how can I?
What charge code, my lord?
Has to pay, no direction.
I'm ready to pay, my lord.
That is why I have given you liberty to
Before
file
you
an
want-
application.
Before your lordship.
No, no, no. That- Yes,
Well, I appear for the petitioner lordship.
yes.
Well, we've come up in challenge from an order dismissing my application under Order 21, Rule 97, read with 101.
Appellable order, sir.
Lordship, in our case, Lordship, the application was dismissed on the ground of jurisdiction. Lordship, we had checked up the available judgments. Lordship, we found an Honorable Supreme Court judgment which specifically says that if the 101 application is disposed of, that we do not have jurisdiction under 101, then the remedy perhaps is to file a civil revision under 227. Lord, may I place that?
You are appearing. Where is the order impugned? Show me the order.
Lordship, the impugned order is at page 42, Lordship.
42.
Page 42, volume 1, Lordship, annexure A.
Impugned order cannot be paginated.
Well, the certified copy is there, but we've annexed it as well only for the
What
purpose
is
of
the date of the order?
Well, this is 21st April 2022. Now, Lordship,
2022.
Lordship, may I explain the facts in brief thereafter? Malad, after this order was passed, instead of approaching this honorable court in revision, I filed an independent suit by accepting this order under mistaken legal advice. Lordship will see a paragraph thus outside the purview of the jurisdiction.
Yes, where is your application under Order 21, Rule 97? Who are you?
Malad, I am the tenant, the bona fide tenant in respect of the premises. Malad, may I explain it in 45 seconds? It will be clear in that.
Just take a little more, you can take 2 minutes.
Lordship, this property was given in tenancy to one Mr. Cook. In 2007, Mr. Cook surrendered the tenancy to the Mutawali. This was a Waqaf property, and it was surrendered in favor of one Neelam Ahmed. Neelam Ahmed came into the property as tenant, affirmed by the Mutawali, confirmed. Neelam Ahmed also surrendered the tenancy in 2008 in my favor. I'm a charitable organization. I run a school there for charitable purposes.
So tenant surrendering tenancy in favor of a third party.
With Lordship, with the consent of the Mutawali, who we have the person surrendering executed affidavit, the Mutawali executed affidavit accepting.
Show me your application under Order 21, Rule 100.
Lordship.
That is at page 190.
Lordship will kindly see page 192 in volume 2, Lordship.
All right, I have got the certified copy. You have also annexed the certified copy of
Lordship.
Yes.
Lordship.
So I have got that. Show me the Supreme Court decision.
Lordship. And before that, may I show one judgment of the appeal court, because I had filed the suit. I got an interim order, they filed an Order 7 Rule 11, Order 7 Rule 11 allowed. I filed an appeal before the division bench of this honorable court. The honorable division bench took note of the circumstance and passed an order. May I just place that order?
What order has been passed?
of upholding the rejection of my plaint, but making
To be, because separate suit is barred during the pendency of a execution case.
Lordship. So,
That's the finding of the division made.
certain clear observations were made as to how I can file how I can approach this honorable court in seeking my remedy under against that order, Lordship. May I just show that? Only may I place one paragraph?
Order.
Malad, the impugned order here, Lordship. There's certain observations made. May I just place those, Lordship, only for the Lordship will kindly see page 244. It starts at page 244. Malad,
Which volume?
Lordship.
Which volume?
Lordship, volume 2, Lordship. Lordship will kindly come to page 247, paragraph 14. Onwards, Lordship, just only that one page, Lordship, kindly.
Since I'm not inclined to take up this matter, let the paper.
Number 31.
Yes. Should have told me before.
Lordship, I actually was not aware, Lordship.
Thank you that you have drawn my attention to the appellate court. Yes, next.
Lord, again, rejection, Lord, of an order asking for recalling of an order passed under order section 26(3) of the West Bengal Premises Tenancy Act.
26(3).
Lord, that subtenancy getting directly under the landlord. Lord, that portion.
So that is ground for the controller.
By the controller.
Then you have to go before the
Lord,
tribunal.
I understand the only difficult kind. But the only difficulty is not
no difficulty, Mr. Kormokar.
The order is
Salt Lake.
Yeah, the only thing is not 2022 order. If some observation can be made, blood.
What observation?
Change brief, blood. It's a change brief immediately. Blood. This step.
Take the benefit of the provisions of the Limitation Act. There,
blood. If your lordship kindly, to some extent, blood. With
there's an appellate remedy, Mr. Kormokar.
I bow down before your lordship. There is no difficulty on that.
Because I can direct exclusion. That will be against you. I can direct exclusion of the time for preparing the civil division application from 17th of July till today. That is right. So if you want, this can be excluded.
Not the point.
Without that, go there, take all the points.
Point here involved is not the original tenant was a defaulter. Lord, having defaulted for about 10-15 years, Lord, he inducts the subtenant and files his application.
Appellate remedy available under the statute.
At this Lord, because your lordship knows, Lord, 2022 order, Lord, they will, Lord.
Even I cannot also entertain that. 2022 civil division also cannot be entertained.
A civil division can be entertained, Lord. But we have learned from your lordship, Lord, civil division can be entertained.
Asun, chale asun.
if that word liberal approach may be not included. Liberal approach, not
Section 5 is liberal.
liberal, everyone knows. Next matter also.
Yes, call the
next
is
matter.
same, same order. 31, 32, same order. Yes, next. 33. 33 who is appearing. Pass over next. 34 expeditious. 34 expeditious disposal.
The petitioner is a plaintiff before the learned court below has filed a suit for partition and permanent injunction lordship. Suits were framed in 2000, back in 2017. The suit was in the year 2024.
What is the miscase for?
This case, one petition under Order 39 Rule 2A was filed.
Has been filed by you.
Yes, lordship.
You want expeditious hearing of what? Suit or the miscase?
The suit is
Suit cannot be expedited. Suit is not ready. It's at the service return stage.
Lordship, the evidence in both the
Cannot be. Madam, cannot be. This application under Article 227 of the
that is on 2023. Evidence of defendants were also
maybe, but service returns, unless the service is completed, I cannot direct.
Lordship, that the thing was happened. After that, defendant number 10 filed two petitions. That is in my petition paragraph number 11.
Yes. Madam, who has not appeared? Why it is for service returns?
Lordship, after allowing that petitions filed with defendant number 10, thereafter service return and evidence was fixed.
Yes. Next. Call the next matter.
Item number 35.
Yes. Short passover.
I am put the Malord cabinet. Let me know that too. You have been served only yesterday, subject to approval, your lordship, my lord.
Mukherjee, caveat, when you have lodged the caveat, you must be ready with the instructions.
No doubt. Here, my lord, what I find that practically a success certificate has already been obtained by my client. And my lord, they made an application there, filed a suit for declaring
that is
fair.
What do you want? You want it tomorrow?
Tomorrow or day after tomorrow, what
Tomorrow. So not today, kore rakho na. 35, not today. Call the next matter.
I am grateful to you.
36. Item 36, my lord, I am for the petitioner.
Yes.
I am a plaintiff in a defamation suit. I have sought for recalling of a witness. My application has been rejected. My lord, thing is, the defendant has in her testimony exhibited her sale deed, but the allegation, the defamatory statement that has been made by the defendant is that I am a notorious and infamous real estate tycoon who is hiring goons to remove her from her property. Now, in her testimony, she has exhibited a sale deed, which was never alluded to prior. Yes, ma'am. Come back to sure.
Next is expeditious disposal. The next is expeditious disposal.
Item number
37.
37.
Yes. Expeditious disposal of a.
You are not hungry, Mr. Gupta. You are not hungry. It's 1:30. We're not hungry till now. Expeditious disposal of what?
Of an execution case, title execution case, 9 of 2002.
Arbitration execution.
Arbitration execution case, it was initially filed, my lord, before a different court. Then, my lord, it had to be refiled because of my lord, section 2(1)(e), my lord, it had to be refiled before the district court, which after that it was transferred. There was a section 47 which was filed by the judgment debtor.
Gupta, it has been fixed on 31st of July for further order and filing appropriate orders from the higher forum.
No.
Review, judgment debtor prefers to file a review petition before the higher forum.
There is nothing has been filed. On this ground, it was adjourned. But nothing has been filed.
Mr. Gupta, this application under Article 2.
But this will not prevent the court from proceeding.
submission, sir.
Yes.
Sir, there was a quorum of Chief Justice and your good self, and there was an order in the appeal which I did in the Chief Justice room. And then I filed a review petition. But then unless the quorum comes, I cannot proceed with the review petition. So how do I go with?
Please mention before the Honorable Chief Justice.
Okay. Thank you.
Yes.
Yes.
I submit my notes of arguments. Item number 2.
Item number?
2 years.
Oh.
In the morning.
Yes. Call the next matter.
Item number 33.
33. देखिए.
Item number 38.
33 टा देखिए 33.
36.
6 ছিল 6 ছিল এক্সট্রাক্ট বান্না কি এরপর
6 টোটাল সময় বলতো না
আপনি তো দুটো সময় বলেছিল দুটো সময় বলেছিল
Pass over next. 30.
36.
36, my lord. This is I have filed a suit for defamation against the OP defendant. Now, in the course, the subject cause of action for the defamation is that the defendant had filed a 144 proceeding against me, in which he had
44 Criminal Procedure Code.
Yes, my lord. I had filed a 144 proceeding against me in which she had alleged that I am a notorious and infamous realtor and I have hired hoodlums to forcibly remove her from her property. And not only that, in the written statement that she has filed, she has doubled down on such defamatory statements, gone on to make several other allegations against me. Be that as it may, in the course of her written statement, nowhere did she ever disclose her claim for ownership of the land in question. Suddenly, when she comes to give testimony and examination in chief, she produces a document despite her objections was exhibited was marked as an exhibit. This deed of conveyance to a property, the property which I claim, which actually belongs to me. Now, I have filed an application for recalling my witness to the limited purpose that I can bring my deed of conveyance onto the record to clarify the situation with regard to ownership. The order passed, my lord.
This is not a suit for ownership.
It is not a suit for ownership. I admit, my lord. But the fact has become relevant owing to the defendant's testimony.
Why?
Because she claims to be the owner of the property and that I have tried to evict her from there.
Recovery of damages.
Yes, my lord. I have no doubt.
So ownership is neither here nor there.
I have no doubt about it.
Can that
my lord, kindly see the reasoning in that order. Can you see the order?
Facts be germane to a suit for defamation.
That is the point, my lord. I am not denying that. I am merely saying how the limited purpose.
Recalling of witness may
limited purpose, my lord.
Yes, may at times be permitted even at a belated stage.
Exactly, my lord.
But there's a rider to that.
Yes, my lord.
If it is necessary for the purpose of effective adjudication of the dispute and for rendering justice.
I'm merely saying, my lord. The point is, this entire situation has arisen to fact situation where I am claiming to be owner of a land. This defendant claims to be the owner of the same land.
That's neither here nor there. In a suit for defamation, how that matters? You are the owner of which property? She is the owner of which property? How that matters? It's only a damage caused to your reputation.
My lord,
that you have to prove.
My lord,
nothing more than that.
Yes, my lord. My lord, the point is, she is relying on this in her defense.
Maybe.
I am to clarify my situation. I am seeking to recall for that limited purpose. If for recalling of witness, I have given a very limited scope for the recall, just to the point of bringing this document onto the record.
No, you had the opportunity to cross-examine the defendant.
Yes, my lord.
So you have a right. You have controverted that.
My lord, I admit, that is the deficiency on my part. I admit it, my lord. But my lord, my point is, the only ground my application for recall.
Let me see the reasoning.
Kindly see, my lord. Kindly see I had first made an application which was defective. That, my lord, that was rejected owing not only to the fact that it was
it was defective. My lord, can you see 44? Petition is not supported by affidavit or verification, which is why it was rejected. And 45, my lord, after passing an order, the plaintiff submits an adjournment petition stating in each line as he intends to proceed for revision. On careful perusal of the conduct of plaintiff all along, it appears to me that submitting a petition to recall witness without observing the legal requirement is nothing but a dilatory tactics, for which I am not inclined to allow the same. Now, my lord, can you see, I then submit a proper application with the schedule of questions on 47. Simple, just to the effect of the sale deed. And now kindly sees the order passed in the impugned order, which is I have annexed certified copy, but I've also annexed a simple copy at page 49. My lord, kindly sees the reasons given. Kindly see the fourth paragraph onward. Third paragraph onward. Learned advocate for the plaintiff submits that it is necessary to file the deed of conveyance by which he purchased property prior to the suit pension purchase of the same by defendant. Plaintiff had submitted some questions in this regard to comply order.
Page 49.
49, my lord. Third paragraph onwards.
Necessary to file the deed of conveyance.
Page 49, my lord. Has the lordship got it?
How that is relevant in a suit for defamation? Whether you are owner of a particular property or not,
my lord,
if there is some defamatory statement,
it is a fact that, yes, my lord, but it is a fact that I am aggrieved by the actions of the defendant, which is why he has gone out and made these allegations against me. She has made false allegations against me. The fact that she has claimed that she is the owner of the land and I am trying to evict her from her.
Decided, can that be decided in a suit for defamation? Whether false allegation or not.
The fact is,
whether that is the defamatory statement as
yes, if there is a defamatory statement,
damage to your reputation and what's the quantum of damages? That's only
my lord, the defamation is that I am employing victims to evict her from.
Yes. So that's the statement.
Yes, so the property is mine. Why would I engage hoodlums to evict her from my own property?
So that's the statement which, according to you, has caused damage to your reputation.
Yes, my lord.
And for which you have suffered damages which you have quantified.
Yes, my lord.
So that's the subject matter of the suit which you have to prove. Nothing more.
Yes, my lord. But my lord, kindly sees this page. Kindly see just before the ordering portion, my lord, paragraph starting with I have perused. I have said, kindly, I will leave it to your lordship after that, my lord. Yeah. Kindly sees, I have perused the decision of Honorable Court reported in AI 2005 Supreme Court 3353. I find that the case is filed with prayer or monetary relief causing defamation. Deed of conveyance which the plaintiff intends to produce at this belated stage was acknowledged and we did not file the same at the appropriate time. At this belated stage, especially after conclusion of argument from this defendant, this court cannot allow adducing further evidence. Will frustrate the defense case.
I can supply the reasons.
Frustrate the defense case, my lord.
I'm supplying the reasons.
My lord, kindly sees, my lord. My lord, this clearly shows that this defense
brought 2011 volume 11 Supreme Court cases. On order 18 rules.
My lord, kindly sees.
Have you brought that decision?
I have not brought that.
You have not brought that decision.
I have not brought that decision, my lord. But kindly see, the frustrated defense case shows that the honorable judge has already made up that my hand has been swayed by presence of that document. Thus, this document becomes crucial to clarify the situation. This document becomes crucial, my lord. The very fact of the usage frustrate the defense case shows that this document that has been produced by the defense has had some effect in swaying the trial judge. And to clarify the situation, I must be allowed
to. Are you carrying any of your gadgets? 2011 volume 11 SSC 275.
2011 volume
11 Supreme Court cases page 275.
Supreme Court cases 275, my lord.
Yes.
K.K. Velusamy Palan.
Yes, yes, yes.
Yes, my lord.
Please give me that.
Yes, my lord. I'm just kidding.
Nearing the last in portion of that judgment, will be finding what are the conditions on which this recalling can be permitted, even at a belated stage.
Paragraph 12. The amended provisions of the court complete.
Thereafter, this is 151. Even after exclusion of Order 18 Rule 17A, 151, it's permissible.
Yes, my lord.
So that's power of the court is there.
Yes, my lord.
Yes, thereafter. So,
17.
nearing the end of the judgment, it
18,
says,
paragraph 18. In this case, we are satisfied. Interests of justice and to prevent abuse of the process of court. Trial court ought to have considered whether it was necessary to reopen the evidence, and if so, in what manner and to what extent further evidence should be permitted in exercise of its power under section 151 of the code. The court ought to have also considered whether it should straightway recall PW1 and PW2 and permit the appellant to confront the said recorded evidence to the said witnesses, or whether it should first receive such evidence by requiring its proof of its authenticity and only then permit it to be confronted to the witnesses. Previously it is said,
yes,
we may add a word of caution. The power under section 151 or order 18 rule 17 of the code is not intended to be used routinely merely for the asking. If so used, it will defeat the very purpose of the various amendments to the code to expedite trials. But where the application is found to be bona fide and where the additional evidence, oral or documentary, will assist the court to clarify the evidence on the issues,
yes,
and will assist in rendering justice.
That's important.
Well, this is the entire point. I'm
Considering the nature of the suit, this evidence cannot be said to be necessary for the purpose of rendering justice.
My lord, I'm making the argument that this entire suit is based on the factum of this person's allegation.
So what are the, do you have the,
with regard to the
you are carrying the issues in the suit?
My lord, the issues are not with me, my lord. It's not annexed here with my lord.
Thank you. Yes, this application under Article 2
Well, it's my application.
Yes.
Well, the application is for expeditious disposal, my lord.
Of what?
Of the section 5 application.
Section 5 in connection with?
In connection with an appeal for restoration of an appeal, before the learned additional district judge, first track court to Shialda, my lord. My lord, I tell your lordship the brief facts of the case, my lord.
What's the next date fixed?
My lord, the next date fixed is at 3rd October 24.
3rd October?
No, 3rd October, no, my lord. 6 August 2025, my lord. My lord, the section 5 application, my lord, the difficulty is, my lord.
In a miscellaneous case?
Yes, my lord. My lord, there was an appeal, there was a decree, my lord. After that, an appeal has been filed, my lord. The petitioner has filed an appeal. The appeal was subsequently being, my lord, dismissed because the advocate could not appear.
What is the suit for?
Suit for eviction, my lord.
Suit for eviction under the West Bengal Premises Tenancy Act.
My lord. The suit was decreed in 2016, my lord. Thereafter, an appeal has been filed by the petitioner. My lord, the
Item number 39. Item number 39 is my application. The challenge to an order rejecting my Order 7 Rule 11. This is a suit for infringement of a trademark.
Nowadays, in all suits, Order 7 Rule 11 applications are filed.
But I'll tell my lord.
The suits are filed in all suits. I think in all the suits I'm getting Order 7 Rule 11. I think this is the 6th or 7th Order 7 Rule 11 today I've got.
Well, this has substance.
All are substance according to the petitioner. Yes.
Suit for infringement of trademark. I am the defendant. Suit has been filed before the district judge at Alipur. Well, the suit comes under the Commercial Courts Act. Well, it's a commercial dispute under the Commercial Courts Act. However, instead of the commercial court, it was filed before the district court. By reducing the valuation of the suit, Lordship knows the valuation of the commercial courts of the districts start from 30 lakhs. They value the suit at 20 lakhs and file it before the district judge. Now, the averments made in the plaint would reveal that the valuation itself is absolutely arbitrary, is manifestly arbitrary, because they say the suit is for
that you have to apply under Section 11.
But insofar as the valuation is concerned, there has to be an inquiry.
Rule 11C.
Yes.
Valuation part.
Yes.
The invocation of jurisdiction can come only after the court
inquires
to a finding that suit is undervalued. After that, court requires the plaintiff to put in the deficit within a such and such time. If not done, then the question of invocation of Order 711C.
Now, Section
so it's at a premature stage now. Unless you can show there is a finding of the learned trial judge that this is the suit has been undervalued, this is the deficit.
No, the learned judge says that at this stage, this cannot be gone into, this cannot be decided. Now, my lord, kindly sees the averments made in the plaint. I'll show my lord where they are. Take
out an appropriate application before that.
Section 11 inquiry can also be done in an Order 7 Rule 11. My lord, I am covered by a judgment which I'll show to your lordship. My lord, in cases of this nature, of infringement of trademarks or infringement of any intellectual property right, filed before the district judge as instead of a commercial court, the inquiry as to whether the suit has been properly valued can be carried out in an application under Order 7 Rule 11. It's a preliminary inquiry which the court can do.
Yes.
This is reported. It's also cited before the sorry. They say, Malad, they have sold their products in the market of that crores, and then they value the suit at 20 lakhs.
Show me that under Order 7 Rule 11 this inquiry can be made.
But at paragraph 54 of this judgment,
this was under Order 7 Rule 11.
This was not under Order 7 Rule 11. This judgment, but it lays down what can the courts do and what can the courts can't.
To show me that under Order 7 Rule 11 this can be done.
My lord, kindly see,
which paragraph?
Paragraph 54(3).
54(3).
If the valuation given by the plaintiff is arbitrary and unreasonable, the court may reject the same and permit the plaintiff to correct the valuation or have the plaint rejected. The valuation must not be arbitrary or manifestly inadequate. Relies upon a previous Supreme Court decision. And
Supreme Court decision.
This judgment summarizes all the points. So that is why
show me that Supreme Court decision. It says under Order 7 Rule 11, without requiring the plaintiff to put in the court fees, plaint can be rejected. Show me that.
I'll bring that judgment. But my point was a little different. My point was in the plaint.
The judgment may not be a binding judgment.
No, not at all. It's a Delhi High Court. It's not binding. What I'm saying before your lordship is that the plaint says that the goodwill they have in the market, insofar as the mark is concerned, how a goodwill is valued by the sales or by the profits. They have sold products worth 35 crores.
Appropriate application, I give you that liberty to take out an appropriate application.
But if your lordship kindly gives me one more day, I'll bring this judgment which has been referred to. Kindly keeps it tomorrow. I'll try and satisfy.
After some argument, the learned.
Sealing an order passed by the learned tribunal of the Indian Chamber of Commerce, but where the right to file the second witness's affidavit of evidence was closed. But we had produced medical documents, and that witness is an expert witness. The issue in the arbitration was the coal and the quality of the coal. So we had to get an expert to lead evidence. Kindly seize the order, my lord. 11th of July.
Eleventh of
July.
Where do I get the date?
At the end, my lord, at the top, my lord, 11th of July.
Oh,
Means
11th
sitting.
of July, yes.
Received by us on 16th of July, but kindly seize, my lord, the third paragraph. But the witness is from Bhubaneswar. But only one day. That day I prayed for an adjournment.
Second witness is fit.
Right is closed.
Yes.
Right
Now
is
he's
closed.
fit, physically fit.
Physically, my lord, he is still in Bhubaneswar. The affidavit is being notarized there.
Now he can come to face
But
cross-examination.
we had prayed for 2 weeks' time. We had prayed for 2 weeks' time because the doctorate had
2
been
weeks
10
time
days from that date.
So it's 26th of July, 2 weeks is over now.
Yes.
So now you have taken instructions, he can come. On 26th, he can appear.
But would your lordship kindly
But,
pass me by for 2 minutes, my lord?
But Mr. Gupta, where is who is representing the other side?
No, they are not on caveat. They are not
I
on
appreciate that. So who is appearing? He is from this court? No.
No.
Clement's
They are
advocate?
from Delhi.
Clement's advocate
They are
is
from Delhi. And I only prayed for 2 weeks' time because the witness is nearly not our person. But he was there in site. In some site, he got injured, suffered a back pain, where a physiotherapy certificate we gave, which the London arbitrator said, I do not.
What was the injury?
Back injury. But we do not know. We have only met him over virtual platform.
So
He is
prior
an
to the
inspection.
physiotherapist, you going to the physiotherapist, you must have gone to an orthopedic.
But I do not know. We have been given that physiotherapy certificate where that was that we have annexed that. And doctor certificate now we have annexed. That
This-
is
this
that was not
application-
before the arbitration.
That's the subsequently procured
Subsequently,
one.
because
Procured one.
yes, but
Yes. So you are admitting that, Mr. Gupta. You are admitting that.
subsequently we had got that.
Procured. I have said you have admitted that. This application.
Number 41.
Yes, Mr. Mahato.
My application for amendment
Matter is being heard in a piecemeal way for so many days. Everything has gone out of my mind. Yes, yes. What is the short issue, legal point?
the amendment
This is the mind.
amendment to controvert the affirmance made in the written statement has been rejected.
What is the applicable provision, Mr. Mahato? Written statement,
replica,
amendment, controverting by an
replica,
additional plaint.
No, it is termed as replication. Replica.
Where is
we
the
usually use.
Under what provision?
It is Supreme Court says, my lord, it is order 8 rule 9.
Plaintiff also. Plaintiff can file order under order 8 rule 9. Show me the decision.
But I have handed over to your lordship.
Oh, you have handed up.
2024-9-53.
Show me that portion where it says plaintiff can file order 8 rule 9.
Yes, my lord. Paragraph 32, last page, my lord. Paragraph 32 and 33.
Paragraph
32 and 33. Paragraph 32, first 4 lines are enough. Last occasion, my lord indicated paragraph 29.
Yes.
My lord, court should not granted the leave mechanical.
No, must bear in mind that the replication is not intended
Yes.
to merely traverse
Yes.
facts pleaded in the written statement.
Yes.
And a replication is not a substitute for an amendment. Here is the amendment application filed. No.
Amendment was filed.
Amendment was filed, not the replication.
But purpose is to deal the statement made in the written statement, which are new, which are not in the part in the plaint.
Show me the amendment.
It starts at page 10.
But Mr. Mahato, have you considered the decision relied upon by Mr. Bagchi on the last occasion?
Hello?
Mr. Bagchi relied upon a
Yes,
decision. Have
that
you
I have seen
considered that?
I have considered that. That
Because
is
that
different.
decision says,
Order 8 rule 9 and order 6 rule 17 different.
yes, and says order 8 rule 9, it's only the defendant, not the plaintiff. That's the submission.
Language says so. Order 8 rule 9 language is like that, that it is only for the defendant to file written statement or additional written statement.
Yes.
There is
So,
no doubt.
So if that is so,
Replica, there is no provision for replica, but replica, the practice is there, and it is Supreme Court says it may be treated as order 8 rule 9. Replica,
yes,
replica practice is there.
if
in our court, petition, opposition, reply. Plain written statement replica. This is the, my lord,
that is a different thing altogether. So, but the
But some new facts if come in written statement, I am to controvert that. That for that purpose, replication provision is there. That provision is, my lord, according to Supreme Court, it may be treated as order 8 rule 9.
here, Mr. Mahato, there is a distinction because in this is what you are saying that this petition, affidavit in opposition, affidavit in reply is because these are decided on affidavits.
Yes.
Because if the respondent says something
I have understood.
in the affidavit
I
in
have understood.
opposition,
I have understood.
so petitioner do not get. But in a civil suit, what you are stating in the written statement, plaintiff has to deny that or say something in the evidence.
Yes.
But
But
that is why
I
so it's not that. So in all matters, what you, if you are suggesting, all matters what you are
if new facts which has not been pleaded in the plaint, that may be is required to be controverted, my lord.
just show me the plaint.
My lord, the plaint, my lord, the
What's the dispute? Tell me in short.
My lord,
What is the plaint case?
My lord, they have in the written statement stated that agreement for.
What is your plaint case?
My lord, plaint case, my lord, it is for. My lord, I have paid for declaration.
Yes.
That by virtue of a registered deed, I have got the property.
Yes.
And for injunction.
Yes. How have you traced your title? How have you traced your title? By virtue of purchase?
Yes.
From?
My lord, I have purchased the property from. My lord, the statement paragraph 2 onwards, my lord, everything has been.
In short, I want to know what's.
My lord, initially Gopal Chandra Monir was the inert. Thereafter, my lord, Surendranath Burman and Narendranath Burman came. They, my lord, partitioned the property. It was recorded. Subsequently, Surendranath Burman had transferred.
Yes.
Well, I have got from Surendranath.
You have got from?
Surendranath.
Yes. So
Paragraph
that is
5.
your plaint case.
Paragraph 5.
So you are deriving your title from Surendranath. Yes. So what's the defense case?
In the written statement, my lord, they have stated that there is an agreement for sale. My lord, paragraph 17. Page, my lord, 3 of the written statement.
No, running page.
No, my lord, it is the branch of papers have been handed over. Huh?
Yes. Page 3.
Page 3, my lord, 17, then 19. বাদী ইংরেজি 27-12-20 তারিখে তাহার গৃহে অবস্থান করা, they have denied this. Paragraph 28, 27, 28, 29, then 30. Up to 32. And last number 34, বাদীকে তাহার প্রাপ্য পণ মূল্যের টাকা মিটাইয়া দেওয়া হইলেও বাদী ভিন্ন অজুহাতে he is not executing the deed. But 2.
So, in the written statement, a case has been made out that there was some agreement between the parties by virtue of which the plaintiff was required to execute a deed in favor of
the defendant.
Durga Mata Thakurani. That the plaintiff has not done.
Yes.
So that is the statement. Now, where is your replica or the amendment?
Revision petition, page 11.
Revision petition, page 11.
It starts at page 10. The schedule of amendment is at page 11. Paragraph 10A. 10 এর ক and 10 10 এর খ.
Mr. Mahato, paragraph 10 q is against the observations of the Supreme Court judgment. So denial cannot be done by way of application also. So 10 q goes,
Yes.
then
10 খ
10 q.
27/12/20 তারিখে বিবাদী বাই কোয়ারশন এন্ড বাই থ্রেট যে সকল ফাঁকা কাগজে বাদীকে স্বাক্ষর করিতে বাধ্য করাইয়াছিল এবং ওই দিন বিবাদীগণ বাদীর নালিশি ভূমি সম্বন্ধীয় দলিলটি অপহরণ আত্মসাৎ করিয়াছে, বাদী কোস্মিন কালে নালিশি ভূমি বিক্রয় দিজাত কুমার। Well, they will not be prejudiced. If the amendment is allowed, they will not be prejudiced in any way. And I have not stated any new fact which has they are to controvert that. That my lord was of the view it will carry on, it will going on. That will not. Well, question amendment, so far amendment is concerned, my lord, scope is, it is very clear. The LIC decision, Supreme Court has held, my lord, that
Only serial 1 was allowed, not the serial number 2.
one
It was
is
allowed in
only
part.
concern of DJ.
It was allowed in part.
Yes.
So
Allowed in-
paragraph 1 was only allowed.
Yes.
10 q, my lord, it is the plain case. 10 q, it is the plain case, paragraph 9. Page 4, paragraph 9. It is the plain case, they have stated already.
Plain case they have stated in paragraph 9.
Yes, sir. Paragraph 9, they have stated 10 q. My lord, kindly have a look at
This case which they have now want to incorporate, that has been stated in the plain.
Yes, sir. This
Paragraph 9.
27. This date was stated.
Some part is there.
So Mr. Yes, this is there.
Some part is there.
So what is not there? This challenge is there. And 10 q by any means cannot be allowed, because this is denial of the written statement case that cannot be allowed even by the decision which you have cited.
No, my lord.
That's
the 10 q.
10 q cannot be allowed.
10 q says, my lord, নালিশি ভূমিতে 10 ক 10 ক
Yes.
নালিশি ভূমিতে বাদীর দীর্ঘকাল অনুপস্থিতির সুযোগ লইয়া বিবাদীগণ জোরপূর্বক নালিশি ভূমি তদস্থিত গৃহ দখল করিবার জন্য নানারূপ চক্রান্ত করিয়াছিল। This is not denial. It is specific statement.
Thereafter.
সেই কারণে বিবাদীগণ তাহার দাখিলি বর্ণনাপত্রে বাদীর সত্য দখলি নালিশি ভূমি ও তদস্থিত পোক্তাগৃহাদি বিক্রয়ে ভুয়া মিথ্যা কাল্পনিক চুক্তির বিবরণ উল্লেখে একটি আষাঢ়ী গল্প সৃজন করিয়াছে। This is also not denial.
This is in effect denial. You are saying that this is a vague statement. কথিত মতে নালিশি ভূমি গৃহ বিক্রয় বিবাদী সহিত কোস্মিন কালে অনুপস্থিতি হয় নাই। This is denial বা নালিশি ভূমিতে তদস্থিত গৃহ করিবা আবশ্যকতা বাদী ছিল না or নয়. All these are denial. Only one statement maybe you have said, but the following statement clarifies that.
Denial, my lord, what is denial? If your lordships kindly see the written statement, denial is plaintiff stated such and such, it is not accepted, it is not admitted, it is denied. That is, my lord, denial. But it is not, some facts are there. Some facts are there. The
Paragraph
first line-
10 q, Mr. Mahato, this is already there in the is already there in the plain.
Paragraph 9, মানে 10 এর ক 10 ক বাদীর দীর্ঘকাল অনুপস্থিতির সুযোগ লইয়া বিবাদীগণ জোরপূর্বক
And what is with regard
This is
to
not denial.
10 এর ঘ?
Well, so far 10 ক, it is not denial. Well, effect may be denial, But the specific statement is there, নালিশি ভূমিতে বাদীর দীর্ঘকাল অনুপস্থিতির সুযোগ লইয়া বিবাদীগণ জোরপূর্বক নালিশি ভূমি অধস্থিত গৃহ দখল করিবার জন্য নানারূপ চক্রান্ত করিয়াছিল. This is not মানে denial.
It is in the plaint.
That is in the plaint,
Mr. Mahato.
File করলেন.
That is in the plaint. And দশের গ, any statement in the plaint? দশের গ.
Yes. My lord,
ঘ.
unless the amendment is necessary, court cannot pass the
No.
judgment.
But Supreme
That
Court,
is amendment without jurisdiction. Necessity, and my lord, no statement has to be, no argument has to be necessary. What is the necessity? When they are claiming title.
LIC decision মানে
And they can give evidence.
withdrawal of admission not permissible, time barred claim not permissible.
Mr. Mahato, the
Basic, my lord,
LIC, it starts with all amendments to be allowed if it is necessary for the purpose of.
Unless it is necessary, court has no jurisdiction.
That's the dominant purpose. If, and when it cannot be allowed, it's the other things. So basic thing which is to be seen is whether it is necessary or not. All right.
My lord, regarding
What?
আপনার ফেভারে আছে আর কি করবে?
Huh? Yes, Mr. Bakshi.
no, my lord, conversion.
Conversion of?
Order 6 rule 17 to order 8 rule 9.
Oh, Mr. Bakshi, this Supreme Court judgment says replication by the plaintiff can be permissible.
Yes, if it is subsequent event, and subsequent event has been allowed.
No, subsequent event, order pleading, there are two things. Order
My lord,
can be.
often happens. Eviction suit, reasonable requirement. If
Requirement
retired
changes.
order come,
Requirement check.
yes, I can file a replica.
No, that is order 6 rule 70.
Replica with respect to an incident of 2008 in 2025 unheard of.
No, Mr. Bakshi, what you are saying that its subsequent event can be brought in by way of an amendment.
Amendment as well as the replica. My lord, kindly see order 8,
Rule
9, rule 8.
Order
8 rule, rule 8 or some.
Order 8 rule 9.
Order 8, rule 9 is subsequent pleadings.
Yes.
Before that, my lord, it always relates to rule 8. And order 6, rule 13. When they can lead evidence and evidence is unnecessary.
Order 6, rule 13.
However, my lord, enough argument is done. No.
Yes, order 6 rule.
You have seen new ground of defense. If this happens, my lord, they have right to file.
Which provision?
Any ground of defense which has been arising after institution of the suit.
Orders, which provision you are saying?
Order
rule 8. Order 8 rule 8. It relates to incident after institution of this suit.
If a defense got a claim, then they have right to file replica. Because in that case, defendant becomes a plaintiff.
Yes.
In that case,
That is counterclaim.
My lord, entire question whether or a challenge, that too in a denial, should relate to a document of 2008, India 2000. It is impossible. And there is no whisper. Even my learned friend, a very able learned friend, has not said anything that it is necessary. Because order 6, rule 13, your lordship, they can do it by evidence. And that was recorded.
Yes, are the learned advocates for the parties? Oh, this is that matter which you are alleging that it will go down, it will not be taken up. Fortunately, I've reached that.
All other matters, my lord, I will have to, my lord, make that submission, my lord, when your lordship, my lord, is.
No, it's not not because of that. It was in its original place, but
I understand.
thankfully for you, I could reach. Yes.
My lord, it's a little section 8, 5 and 8 allowed.
Some perceptions are best not expressed aloud, like Mr. Chatterjee expressed.
Yes.
5 and 8, my lord, rejected Arbitration Act. My lord, on two grounds. One not taken by the trial court, the other one the appellate court has taken it. My lord,
oh, this after that you went to appeal.
So now it's an appealable order.
Yes.
So there, my lord, the appellate court has held that, my lord, 8.2 is fatal. Since I have not filed, my lord, the original. So that is fatal. Now, what the appellate court did not notice, my lord, is that I had made a statement in the application that the original is not with me, which they have dealt with, my lord, saying that the original is with me. So without an adjudication to that effect, 8.2 could not have been, my lord, could not have been adhered.
So you have filed a copy of that agreement.
I have a certified copy, an authentic
certified copy,
authenticated certified copy, notarized. Sorry, notarized. My lord, if your lordship turns to my application once and sees paragraph 8, kindly sees to, my lord, paragraph, I'm sorry, page 35, and have a look at page 37.
What's the nature of the agreement?
My lord, it's basically, my lord, an unregistered development agreement. My lord, your lordship sees paragraph 8, it's there.
Page 35, paragraph?
37, 35 it starts,
Yes.
37, paragraph 8. The original development agreement dated such and such is lying with the plaintiff of this suit, and the plaintiff is called upon to produce the same at the time of hearing of this application. Your petitioner has been in custody of a true photostat copy of the said development agreement containing seal and signature of the respective parties and a duly arbitration. I'll take your lordship to that, but it's a little, I'm saying a little differently.
Yes.
And a duly attested copy of the said photocopies of the development agreement is filed herewith and made annexure A hereof. Lord, the opposition
not annexed.
No, my lord, it's not. I'm sorry, my lord. It's our fault. We should have annexed it.
File a supplementary affidavit, Chatterjee.
Not before this court. তোমার opposition. তোমার নেই. তোমার কাছে তো opposition. Have a look at paragraph 8. And also sees, my lord, the one which is written in handwriting.
Paragraph 8.
8. They have dealt with, my lord, there at paragraph 8. Paragraph 8
is lying with the plaintiff.
Yes.
So they admit that it's with
exactly
them.
what I'm trying to say.
No, I was under the impression that they were saying it's with you.
Did not, my lord. That's why I say I don't know whether this is a mistake or not, because I think it might have been a mistake, and I should be fair, my lord.
No. Cannot be, because it says
no, in the middle they have
that
said
he has to apply and that the original is Oh, is false.
Yeah. So it's not that.
The original agreement is in the custody of the defendant. So this was there in the original.
Yes, it's there. my lord.
Handwritten part.
My learned senior friend is here, my lord.
Mr. Chaturvedi, please.
May I look into it?
Whether this handwritten part was.
That's exactly what I wanted to, my lord, check.
The handwritten part.
Handwritten part.
First part is denial.
Yes.
First part is denial. Next is the positive assertion.
Yes.
That the original development agreement is lying with the plaintiff.
No, eight other.
Handwritten part. Handwritten
Cannot
part.
be. Cannot be.
No, handwriting part to onno ache babe.
It's not there in the original.
It is, I do not know, my lord, this, since this is not supplied to me,
but this is your document.
Just a second, sir. Since this is not a part of the petition, my lord, I cannot readily, my lord, answer it. But I say, if both the lines read in consecutive, my lord, are to be holistically understood. The first line says that it is lying with the defendants. Kindly see that the original development agreement is lying with the plaintiff and the defendant have only a photostat copy.
No, he is saying about.
Please complete that. Please complete that. Please read that in full.
Yes, that the defendant have only a photostat copy are out and out false. This is
Yes.
what I'm saying.
Yes. Then please kindly come to the next handwritten portion.
The handwritten portion. The handwritten portion is does not make any sense if we read the previous lines.
Handwritten portion makes sense if you.
No. If it is, I say, then I need to not take instruction as.
Mr. Chatterjee is the defendant.
Yes.
So Mr. Chatterjee says, and you are the plaintiff.
Yes.
Mr. Chatterjee says that it's lying with you. That's Mr. Chatterjee's case. Your case is that Mr. Chatterjee is saying it's lying with you is out and out false and baseless.
Yes.
And
you're
asserting. It is lying with him. That's the handwritten portion. So it makes sense. It does not say that it makes sense. So your case has been made out. I'm only asking you whether that handwritten portion is there. Because if that is not there, it's a different thing altogether.
No.
Because since it's in handwriting, that is why I'm asking you.
Milord, Mr. Chatterjee, Milord, is relying on this. I say I cannot, Milord, I have no knowledge about this because this is not a part of it. I say even ignoring this, the categorical stand is that it is with plaintiff. And plaintiff have admitted by annexing the document at page 40, the agreement itself. I'm sorry, Milord, if I'm interrupting Mr. Chatterjee.
No, not at all.
We are only assisting.
Yes.
Kindly see.
Page 40.
Page 40.
Yes.
This is the agreement.
Yes, you have annexed this copy.
Mr. Chatterjee has annexed this copy.
No, Mr. Chatterjee, no. Mr. Chaturvedi, it's your suit.
Yes.
It's your suit.
My suit, I say when they file section 8 application.
Let me understand this. You have filed a suit?
Yes.
What is the suit for? Take me to the plaint. Is this agreement disclosed by you in the plaint?
Yes.
Show me that. Show me the plaintiff, the disclosure of the document.
Yes.
Show me.
Kindly first, Milord, sees what have I asked for. Kindly comes to page 24. Let the suits are kindly sees, Milord, page 25 is the suit for injunction.
Mandatory injunction.
Mandatory injunction.
Paragraph 6 at page 27.
And
the said agreement dated 7th of March 2012 was executed in preliminary form and the plaintiff firm entered into the agreement with the understanding that the property mentioned in the A schedule will be developed with the tenure of the agreement and the plaintiff firm.
Documents will be planned.
Now, Mr. Chaturvedi, your suit.
Kindly see what I have prayed.
You have made out a case that some development agreement was entered into between you and Mr. Chatterjee's client. And pursuant to that agreement, you have handed over to him some documents which have been mentioned in Schedule B at page 33. So that is your positive case. The cause of action for handing over these documents to Mr. Chatterjee's client is, or if I can put it in a different way,
Related.
the development agreement forms the basis of
Yes.
handing over these documents to Mr.
And
Chatterjee.
it's related.
That's your positive case in the plaint.
Plaint.
And you say time is the essence. There must be something which Mr. Chatterjee's client could not adhere to the time limits or the time fixed. So now you want him to give you back those original documents which you have handed over to him along with that or pursuant to that development agreement. I think that's the scope of your suit. That's the scope of your suit. So now is the development agreement is also admitted by you.
Yes.
Or execution is not denied by you.
No, no.
So if that is so, now the question is, who is in custody of the original? Because for section 5 and 8, I think the original has to be produced.
That's why I was indicating, Lord, kindly come to page 40.
40.
40.
Yes.
The kindly sees, my lord, the endorsement at the right-hand side bottom.
Yes.
By a notary.
Yes.
See, true copy attested. Now, my lord knows, my lord, Notaries Act, section 8. But kindly do not go by what the practices and procedures are. We all know.
According to you, without the original, how could it be attested?
This is an admission that the plaintiffs, that the defendants have it. Or else they could not have obtained this endorsement on each of the pages.
Yes, yes, that has to be, the law requires that.
And
so attestation by the notary presumes that he is in possession of.
He doesn't only say attested, he says true copy, means he has verified. If he either he says I am not relying on this document, then I say that you did not file any document with section 8. If he says that I am relying on this document, then I say that the original is with you. Then your statements as contained in the application, which is, my lord, annexed at page 37.
So that's the only dispute.
That is the only dispute. Can you see page 37? He says that the original paragraph 8 is lying with the plaintiff. And now, my lord, kindly sees, my lord, before both of us, my lord, came to assist your lordships, Mr. Chatterjee was trashing some judgments which I was reading. He said that these judgments are not good enough. And my lord, I am surprised that by seeing the judge's name,
this is
how can, my lord, an advocate of his nature,
privileged communication between you and me.
How can an advocate of his nature, by only looking into the name of an honorable judge who is no more, my lord, make such a statement? My lord, I took a strong exception to this. Now the law laid down, the law laid down, my lord, is.
It's about my father he's talking about.
Please, Mr. Chatterjee.
Mr. Chatterjee, please. Now we are.
I did not say anything. Mr. Chaturvedi.
This is why I'm requesting both of you, please. Now.
My lord,
I'm not saying
the
anything.
law laid down, my lord, in the judgments are that 8-2 is mandatory. 8-2 is mandatory.
So now let me place my case. My lord,
Yes, yes.
he has told your lordship, my lord, our privileged communication should not have.
No.
Should
Let
not
us.
have, but that's a
please,
different thing altogether. Now, my lord, my respectful submission is there needed to be an adjudication with respect to where the original lies. My lord, this is not a presumptive thing. This is not a presumptive thing. My lord, I have taken a copy of what I had with me to the notary public, my lord, and he has seen that and he has said that true as attested. He might have seen, might not have seen. That is subject to, my lord, even for, my lord, if required, he had to come and give evidence on that.
Not necessary, Mr. Chatterjee.
This was
not necessary because this presupposes that it's with you. Cannot be, because we have to, courts have to presume that all acts have been duly performed by the notary.
She presumes that if suppose, my lord, that there is a problem between X and Y, that look here, there is a problem with respect to in whose custody the document is. 8-2 mandatory, nobody is going to, my lord, even quarrel with that. It's settled law. I'm not even getting into that. Why is it mandatory? To see the authenticity. Nothing beyond that. It's not that because 8.2 is there, that's why the arbitration clause becomes inoperative. No. You are admitting this document? Yes. Have a look at it. Why 8.2 was there? Here. Come on. Now, see, my lord, the application referred to in subsection 1 shall not be entertained.
Mr. Chaturvedi, only one thing.
Or a duly certified copy thereof.
That is why. Please take up section 8, section 2 once.
It was. Yes,
accompanied by the original arbitration agreement or a duly certified copy thereof. So a duly certified copy has been produced. May not be the original.
This is not duly certified. The appellate court has said that this is not a duly certified copy.
What's the reason? What is the reason for the appellate court arriving at that finding?
Yes, because in paragraph 8, the plaintiff says that I do not have the original. And he produces a document which says that this is a true copy. Without original, the true copy could not.
Who produced? Plaintiff, you?
No.
Defendant.
Defendant.
Or.
So he produces
Not
a
and, it's or.
Sir, please. If I have the original, I have the liberty of either producing the original or I can produce a certified copy. Now, I do not have the original. And it is an unregistered document. I cannot procure a certified copy from the registration authorities. Now, to get a certificate of a true copy, I need to produce the original and then secure a certificate of the copy being a true copy. Lord, I come again. If it is a registered document, Lord, I shall.
Oh, I got it.
I'm grateful. Now, in paragraph 8, once he says that he does not have a original, then Lord, page 40 has to be discarded.
So, according to you, this copy cannot be said to be
a true.
If Mr. Chatterjee's case is that the original is not with him,
yes,
then this copy cannot be said to be a certified copy.
Yes.
According to you.
Yes.
All right. Yes, Mr. Chatterjee.
Now, my lord, if that is the submission, that's beyond 8.2. Lord, if I have an original, even then I can produce a certified copy. Take it for granted, my lord, that I have the original. Am I not, my lord, entitled to produce the truly certified copy? He's accepting, my lord, that this is a truly certified copy. He accepts it. That's his submission.
No.
Submission
Please, Mr. Chatterjee, then
submission is not that this is the duly certified.
No, my lord, he says so. I'll tell you, Lordship, how he said so. I'll explain how he said so.
If original is with
I'll
you,
explain, my lord, how he says so. I'll explain to that to your Lordship. My lord, he shows your Lordship the attestation. He says that if he did not see the attestation, he could not have certified that this was true. I hope Mr. Trivedi is ad item on that.
I take an exception to this.
Chaturvedi, I'm sorry. Sorry. Now, he accepts what he said there. Then he says, my lord, that since I have the original, I could not have produced the certified copy. There's a difference between the two. The provision is not that. Vidya which he's talking about, my lord, says 8.2 is mandatory. I bow down. 8.2 is mandatory. And that's why 8.2 has two parts to it. One is the original and says or. It doesn't say that if you have the original has to be produced. No. In Vidya's Rodya, none of them were produced. That's why the Supreme Court says that, look here, might have said whatever I have said, but privately, not for the court to hear that. So, Vidya Dolya doesn't say, my lord, that 8.2 has to be followed, that if you have the original, you have to produce the original. No, the question is or. The provision says or. So, I have a right to produce a true certified copy. What Mr. Chaturvedi said when he was submitting was, since I had the original, I have the truly certified, true attested copy. Once it is said true attested copy, once it says it's true attested, so it means that it's true, and he says that it has a presumption. He said, There is, my lord, now I have this, so your lordship can, my lord. So I am on that. So once he can't have the cake and eat it too. He can't say, my lord, that I will be thrown out at any given point of time. The court did not notice that at all. That part of 8.2, my lord, the appellate court.
Show me that.
Yes. Can you
I think
transfer?
that's the only reasoning.
There is another reasoning. It says that it's not arbitrable either.
It's not arbitrable.
Arbitrable. Kindly have a look at.
So if that is
paragraph
there,
15.
Mr. Chatterjee, we need not go into all this.
No, I first crossed this hurdle because this is a hurdle. Whether 8.2 is complied with or not is the first hurdle, and then I'll come to arbitrability.
If it is not an arbitrable,
Your lordship has said, why is it arbitrable? My lord, while explaining it to my learned senior friend, my lord, your lordship has explained it, my lord, why it's arbitrable.
no, that
Because
was
the
to counter
arbitration-
Mr. Chaturvedi.
Absolutely.
So
So
that's not.
I am relying upon that, where it says that in any dispute relating to that development agreement is arbitrable. That's the arbitration
Show
clause.
me that
So I'll first cross this hurdle, my lord. Kindly it looks to internal page 13
of the
appellate court's order.
appellate court is the civil judge senior division.
Appellate court is the senior judge, senior division.
Yes,
My
yes.
lord, I'm a little perplexed by this, but
Why?
because it says, my lord, it's appealable under section 37.
Yes, I was also thinking that whether it's an appealable order or not.
It is an appealable order. They amended the provision. But whether it's appealable before the senior judge,
Provision of appeal is 37.
37. Bedcourt 37.
Refusing to refer.
Yes, this is that, refusing to refer. But where the appeal will go, my lord, is to the principal civil court.
Appeals from, notwithstanding anything that the shall lie from the following orders and from no orders to the court authorized by law
appeals.
to hear appeals from original
Degrees of the court. So that has to be the district judge. And whether this senior, because my learned senior friend did not take this point, my lord, that's why I'm a little surprised
So
there.
the suit was before which court?
Junior division. But
Yes.
whether it's been delegated, whether there is an order authorizing, because it says authorized by law, whether the district judge has authorized, point never taken. But even if the point not taken, my lord, if the appellate court did not have
Because
jurisdiction,
yes, junior division appeal lies before the district judge.
district judge. And
By
then,
virtue of that delegation,
yes,
it's been
whether they-
transferred to senior division.
absolutely. That's exactly what my understanding was. But since Mr. Chaturvedi did not take that point, my lord, I did not, my lord, go on with it. But whether there was a delegation or not, I don't know from here. I don't know. But even before the court, my lord, there was not a point taken. Not a point taken.
Then it will be a nullity according to you.
If there is no delegation, it will be another.
But it is an appeal preferred by you.
That's absolutely. Even if it's preferred by me, my lord,
You can, so
I can
it will
then
be,
go to
you
the,
have to be given a liberty to
get it
approach the
transferred with
appropriate,
absolutely.
that is one way of looking at it.
It is, and
So
it
if
goes
it
to the
is,
root. It goes to the root. I go into the merits, I don't have a problem at all. But what am I defending is very, my lord, I am
Mr.
not.
Chaturvedi, what do you say to this?
37 for a moment. 37(1). Notwithstanding anything contained in any
37(1). Yes.
Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders to the court authorized by law to hear appeals from the original decree of the court passing the order.
So authorized by law here is Bengal, Agra, Assam.
No.
No. Now kindly see.
To hear.
To hear the appeal, my lord, would be
Original decree. Decree will be of the civil court.
No.
Decree will be of the civil court.
No.
So it has to follow Bengal, Agra, Assam.
So
Civil
kindly
Court
see,
Act.
Lord, court is defined in the act. Kindly see 2E.
So because unless it is referred to, it is before the civil court, Bengal, Agra, Assam
I bow down.
will follow.
Yes. But if there was, my lord, an arbitration.
Mr. Chatterjee, if Section 8 is allowed.
I bowed down.
Then it goes out. So it goes to the tribunal. So there is no decree
In
passing.
no.
No, there is no question of original decree appeal. So original decree appeal
Bengal
is
Agra.
Section 8
Now
is
this
not
has been
there.
sent to the larger bench with respect to the Andaman matter.
Andaman, it's clear.
A little
It's
different.
clear. Andaman, it's clear.
Division bench is saying that Bengal Agra will lie.
There is a subsequent division bench, Mr. Chatterjee.
It's now sent
So-
to the larger bench.
That is being sent, I tell you, because I had in the administrative side, I had the occasion to do this.
I understand. I was arguing that matter.
Because Mr. Chatterjee, I tell you, as
Right
the
from government of India Act in 1935, it came
so
from
it's
there.
only
I bow down.
So district judge,
There is a
irrespective
division.
of valuation,
The Supreme Court
there is a
pending
division bench judgment, you are right, which
in
holds
Andaman.
Bengal, Agra, Assam.
So now
So there is another division
judges-
bench which has differed. So, and
the
has
occasion
to be
to appear
referred
there.
because differing.
I
But
had
the
the
Supreme
occasion
Court
to
SLP
appear.
is pending.
A Supreme Court has called for your lordship's opinion, my lord, on
We
this.
have given that. We have
Your lordship has sent it. I heard because Justice Shobojaji Bhattacharya was there. Now the larger bench is comprising of Justice Bharadwaj, who passed the earlier.
Justice
Shobojaji
Bhattacharya is also
Bhattacharya
there.
and Justice Shampa Sharkar. And it was being heard last week.
Yes,
In
because
fixed
since it has there is a difference of opinion, it has to go before the larger
But
bench.
even here, my lord, coming back to this, I believe it should go to the district judge.
You have the copy of the Bengal Agra.
My lord, we'll have it online.
Yes, yes. Because
21.
here it's has to be original decree court authorized has to be Bengal Agra. So it's a suit. So that is has to be seen. So even if
Now, what we need to find out if there is a delegation or not.
even if without that, because we have to follow Mr. Chatterjee, it's not the Arbitration Act. It's the Bengal Agra.
Bengal Agra.
So if that delegation to hear original decree, if it is omnibus delegation, so civil judge senior division, so it can be. I think there may not be any problem. Please check up the forum.
No, my lord, according to me, it should be district judge. There is no dispute on that. I don't even make that. My lord, I was a little skeptical because it's my appeal, but I am trying to, my lord, defend something where, my lord, it might be a nullity. But the registry could not have even, my lord, registered that. The key should be registered first miscellaneous appeal. এখানে কোনো point তোরা নিসনি about the judge not having any jurisdiction whatsoever. You could not have. তোর appeal যদি যার কাছে এসে appeal file করে দিবি।
But the function of receiving the appeal lies to the district judge has been assigned to the additional judge. High Court may with the previous sanction direct by notification that appeals lying to the district
It's valued at 100.
from all or any of the decrees shall be preferred to the court of no
ওখানে
Mr. Chatterjee
valued at 100.
21-4. Do you have any other
21-4.
copy?
21-4.
21-4. The High Court may with the previous sanction of the state government direct by notification in the official gazette that appeals lying to the district judge under subsection 2 from all or any of the decrees or orders of the Munsif, so civil judge junior division, shall be preferred to the court of such subordinate judge as the case may be mentioned in the and the appeal shall thereupon be preferred across so civil judge senior division.
That's exactly what I'm trying to say. There
now
has to be a delegation there.
so delegation is there There's a delegation because you know from civil judge senior division it goes to the, it's being filed
Additional
before the
district
district judge, but
and then
it's
sent to the additional district judge.
no. Additional district judge is that it's subordinate. This is not the additional district, subordinate judge. Subordinate judge is the assistant
Not in some
assistant
courts,
district judge, not the additional district judge.
some courts, there are, it's senior division or additional district judges,
Not additional,
assistant district judges.
Assistant and additional is different.
Different.
Assistant is civil judge, senior division
Bound,
is being
I
so.
completely bound.
So
But then I would
it is
not
senior division. So there is no
dispute. Very well.
I think there is no dispute and
I
we
have no problem.
did not go
Very
into
well.
that.
I have no problem.
Additional information, my lord, possibly this did not strike any of us. Is Chandanagar court is a subdivisional court. There, my lord, it is headed by the civil judge senior division only. So all appeals, my lord, are heard by the civil judge senior division.
Oh.
I do not know if it helps.
No. It doesn't help. District judge is one. And
Yes.
where is he? Is it?
No, but Mr. Chatterjee,
By delegation,
what yes, Mr. Choturvedi says is right in some stations. So it has to be the appeals have
Before
to be by notification.
by delegation.
Here I think it has to be by
No, my lord, lordship satisfies my lord self. I have no problems on it at all. But it is my duty to point out that this is what it is. My lord now comes to on merits, comes to my lord internal page 12.
yes.
And sees internal number 9.
Number
9.
yes, Roman 9.
9. Paragraph 32.
Yes.
Further, the development agreement dated 7th of March 2012 being unregistered, no certified copy from any registering authority could ever be produced. Completely, my lord, misdirected itself. The appellants have filed only a photocopy which lacks any certification. In the absence of the original, the absent registration, no certified copy is possible, rendering the Section 8 application non-maintainable ab initio.
Mr. Chatterjee, this expression in section 8.2, duly certified copy, I think it has been decided. What does it mean?
It has to be, my lord, duly certified. Where if
Any
it's an
decision on this?
unregistered-
Any interpretation on this?
I can get your lordship.
I
lord,
think
but then
it has been decided
because
because
it's as clear as water.
because certified copy as usual in registered documents, no difficulty because the registration
But it
authority
needs authentication. I'm making it even simpler. This agreement is admitted. This agreement is the plaintiff's document.
and certified under the Notaries
Under
Act.
the Notaries Act, he is
Notary
making a
can
submission.
certify.
Can satisfy, and he is making that submission.
So it does not say that it's by the.
It has to be by the registered authority. No, cannot be. My lord, if a sale deed, I can understand it's something which is registered and a certified copy is taken. My lord, if the provision is looked into
8.2,
have a look at the odd. এই হচ্ছে প্রবলেম ওদের duly certified copy doesn't mean, my lord, from the
You have a
certified
copy of the
authority.
Notaries Act.
I will get it out.
আচ্ছা, এখানে পাবো।
Section 8 deals with it.
Huh?
Section 8
Notaries Act. Plus কর অন্যটায় বেরিয়ে যাবে তো দুটো একটা একসঙ্গে দেওয়া যাবে
8.
It's easier, Mr. Chatterjee. I have found out. Before 8.
Kindly see 8.1. Powers and functions.
Yes, certify.
Authenticate,
Certify or attest
or
the execution of any instrument.
Verify, authenticate, certify or attest.
So this is verify, authenticate, certify or attest.
The execution of any instrument.
That is a different thing.
Execution.
No, execution notary is not here. Mr. Chatterjee, there are two things. Execution is, if it is some document is executed in the presence of the notary, he can certify or attest.
He's like the witness in a will.
So That's A may not apply here. B. Yes, G. Please take up G. Prepare, attest, or authenticate any instrument intended to take effect in any country or place outside in such form, language. I think attest, authenticate any instrument. This is authentication of a photocopy.
Milord, if your lordship sees, the A part itself, 1A, verify, authenticate, certify, or attest the execution, or.
Yes.
So it's disjunctive.
Yes, but
So
what
he
is-
can verify, he can authenticate,
By
he
what?
can certify.
Mr. Chatterjee, all deals with execution of the instrument.
No, that's what I'm on. Have a look at it.
Yes.
He can verify, authenticate, certify, or
attest
the execution of any instrument. That is the togetherness. Or attest the execution of any instrument. That's together. So what is it, Milord? Is basically it authenticates the veracity of the document.
Mr. Chatterjee, it cannot make sense. If you say attest the execution is one thing, others are disjunctive. What does this verify mean? Verify
I
is
am saying, Milord, he can verify, he
Verify
can
what?
authenticate, or he can certify
Verify what?
the execution of any instrument.
Verify, Mr. Chatterjee, execution, authenticate the execution means he has to be present at the time of execution. Otherwise, he cannot either attest or certify or verify or authenticate. There are two things. As you have said, witness like that. If some documents are executed in the presence of the
Simplifying it as simple as possible. He has the powers to authenticate a document. Let's put it that way.
Where is that? This says execution A may not help.
Certify. He can certify the execution of the agreement. He can do that under the law. If your lordship says it's not disjunctive, or rather it is disjunctive, then what he can do is, Milord, he can verify, authenticate, certify, or attest the execution of any instrument. Now, what has he done here? At page 40, Milord kindly comes back.
But there has to be some provision because that's the power of the notary.
Yes, true copy. By any other act which may be prescribed. ওটা হচ্ছে omnibus একটা clause কিছু যেটা রয়েছে আলাদা করে prescription হয়। আমি দেখি done here. True copy attested. This is what the act is.
There is a decision you can check up, 1992 Bombay, AIR 1992 Bombay 149. Because this deals with some comments are there here. This may of some assistance in this. It says when a certified copy of a document, which is a true copy of original, is executed, a notary has to make its entry in the register and put his signature and seal on the copy of the document. As far as the identity of the execution, the notary is bound to take. That's a different thing. So seal on the document.
My lord. And he's done that.
Judgment you can consider.
But what happens is, I'll tell your lordship, simplifying it. There is an original, there is a Xerox. What the notary can do, and which gives an authenticity to it, is when the Xerox one, the photocopied one, he compares it with the original and says this is truly attested copy. That
So Chatterjee, that's only secondary evidence.
Exactly.
So secondary evidence, when you lead a secondary evidence, a copy of some original document.
Bow down.
So when you come to the witness box, you will be saying that the person, yes, this is the copy of that. I have made that copy from such and such by such and such process. I have compared it with the original, and so
I've seen that this is the original.
This is the I've compared it with the
original.
I've compared it with the original.
It gives an authenticity.
So the notary exactly does that
Gives
part.
authenticity to the photocopy. Nothing beyond that.
Yes.
Nothing beyond that. So he certifies, my lord, that this is the original. He can do that under 8.1, as my learned senior friend says.
I do not know, my lord. Time and again when he says that my learned senior friend says, I think he is putting words in my mouth.
Yes, yes. That he always does. Put words.
একটু আগে আর্গুমেন্ট করলে না
He requires a whitewash to improve his image.
racist comment.
Yes.
Now, my lord, that's what his submissions were. His submission was here that I have produced an attested copy, so I must have the original. So he says that this is an authentic document. But I cannot produce this because I have the original. The provision of Section 8 doesn't want that. It is not a requirement under Section 8. If you say that this is an attested copy, you
So
can't.
this is one of the reasons. Where is the other?
That it's a continuation of that.
Show me that. So it says in the absence of registration, this cannot be said to be a certified
Paragraph
copy.
40, yes. Then paragraph 40, my lord.
25 onwards.
Cease
Second reason is paragraph 25 onwards.
এবার যদি আমি বলি, then he will say, why is he putting words into my mouth?
Yes.
জিজ্ঞেস করতে হবে, আমি বলছি তো।
Paragraph 40.
Paragraph 40, my lord, can you finish it? The appellant's application under section 8.1 was never entertained in compliance with section 8.2. And they made no attempt to cure during adjudication. Furthermore, the dispute does not lie within arbitrable scope.
So where is the reasoning of this?
Of the second part.
Yes.
Of the arbitrable
does not
scope.
lie within arbitrable
Yes.
scope.
Now comes back to the trial court's judgment first.
But the appeal court has not decided.
Has.
Yes.
The
Show me that
appeal-
from the appeal court.
Very well. Appeal court, my lord, kindly, he's gone on to all that judgments and everything. Then paragraph 16, he has referred to NN Global, judgments referred to. Kindly turns over to my lord.
NN Global is insufficiently stamped.
Yes, that doesn't matter.
I think
It doesn't, nothing turns on that. Looks to internal page 10.
10.
Sees paragraph 25. On the nature of the suit and the substance of the dispute, non-arbitrable claim. This is the heading of that pilot paragraph.
Yes.
The suit instituted is one seeking mandatory injunction for return of documents which were allegedly retained by the defendants even after expiry of the development agreement. The plaintiff does not seek enforcement of the said agreement. Kindly marks this, very important. I will take your lordship to the arbitration clause. Lord, would it be my lord's pleasure to see the arbitration clause once first and then go into the reasoning? Then I can show my lord how wrong the learned judge was. Kindly turns to my lord, page 57. And then I will also rely upon what fell from Milo while explaining the dispute.
So you are also putting words into my mouth.
The problem is the words come out from people when I point it out, they feel the milord that I'm putting that into their mouth. Not that. Have a look at page 57.
Yes.
In the event of any dispute or difference arises by and between the parties hereto, either concerning or touching upon any of the terms, kindly read, I'll read it very slowly. Terms and conditions of the agreement or any obligation arising out of or under the same or any other matter arising out of or in any manner related thereto. So any dispute which relates to that agreement is arbitrable. My respectful submission.
Obligations arising out of that.
Any matter relating to that document or to that agreement. I am on this. Then my lord kindly turns back to the impugned order.
Page 10.
Page 10. The suit instituted is one seeking mandatory injunction for return of documents which were allegedly retained by the defendants even after the expiry of the development agreement. So, my lord, the documents which he wants back is related to that development agreement. The plaintiff does not seek enforcement of the said agreement or adjudication of claims arising under its terms. Marks it. The reliefs are confined to a civil right grounded in possessory, recovery, and restitution. The present suit is for mandatory injunction, mandatory restoration, and return of original documents framed upon property or bailment principles. This is not nobody's case. Then, the suit founded on possession of original documents is a possessory and restitutionary claim, fundamentally distinct from contractual interpretation or enforcement. Honorable Supreme Court precedent mandates referrals only when disputes arise out of or are connected with the contractual instrument containing the arbitration clause. A possessory action falls outside the ambit. The appellants argue that the dispute emanates from the development agreement. So this argument was made there, and therefore falls within the arbitration clause. However, as rightly noted by the learned trial court, the relief sought by the respondent is mandatory injunction for the return of original documents, a possessory claim under the bailment law, and not a claim for performance or breach of the development agreement. In MR such and such, the Honorable Supreme Court observed that consumer and equitable disputes are restitution of possession, even
Strategy, what is 2019 12 SCC 751? Which the learned trial judge,
even when tangentially linked to an agreement are not arbitrary. I am not even saying that it's tangentially. I am saying it's direct. I'm not even getting into the tangent.
It says disputes like restitution of possession.
My lord.
Even if it is
when
linked to agreement are not non
about possession means possession of my lord, physical possession of a property. My lord, this is a dispute whether I have to give back those documents or not. This is a suit for. That document, my lord, emanates from the development agreement. That's his plain case. He can't say no. That's his plain case. It's related to the development agreement. My lord, it's admitted everywhere. His plaint is on that. So the learned judge is only not looking into, my lord, whether it's a claim out of that agreement or not. No. It's a claim related to that agreement, and that's arbitrable directly. It's not tangential. It's directly arbitrable.
I think this is a very good case for mediation.
For my lord?
Mediation.
I don't even know why are we fighting. These documents have to be given back.
Yes, Mr. Chatterjee. That is why. That's
but after
the,
so much of hearing, my lord, lordship decides.
But if this is so, this only, Mr. Chatterjee, with regard to the return of these documents only.
Yes. But after so much of hearing, my lord, kindly do not send it to mediation. My lord decides it.
Mediation, Mr. Chatterjee, I can appoint both of you as mediators.
I am, my lord, I am extremely, my lord, dependent on my learned senior friend.
Why are you fighting for these documents only?
Why are we fighting?
Because
I really didn't take instruction on this.
I think this is we are fighting out on this free. There was a development agreement. Some documents were given.
Original teeth they wanted that.
That's one is development goes not goes. Because since you have started with a point of law, I was with that. Though I have seen that prayers, but now it finds that if that is the, if it can be.
It's gone that formula then.
Yes, I should have been pointing out at the very initial stage. I should not have taxed both of you on this. But
no, my lord, it's a pleasure. My lord, this is on a point of law completely.
Yes, on a point of law, maybe in a different case. Maybe we can try it out on a different case. But if this is the short, yes, Mr. Chaudhary, what do you say?
As your lordship pleases. I leave it to your lordships. But
Do not
interesting
send
point.
it to mediation right away.
Point, no
I'll
doubt.
take
The
instruction.
strategy. If this is the document, if there is no real dispute. So after all, these are the original documents, you may say. If you are also not, yes, Schedule B. Schedule B he wants, which
let
page?
me just talk to the client once I have.
Yes, yes, otherwise you cannot commit anything.
I cannot.
So
Schedule B was the original.
that is the only relief in the suit.
Only
Which he has claimed. Original settlement records, original sanction building plan, and original sale deed. Mr. Chatterjee, if so nothing, you cannot by keeping custody of this, you cannot also become the owner of that. So whatever your rights you have, original sanction building plan might have lapsed. I do not know it in the meantime.
And prepared, my lord, it's all given, done and dusted.
Second is original settlement records, copies. The computerized copies are also available. If you people do not return that, so original sale deed also. Let us assume that
Destroyed.
Yes, destroyed.
No, I was just wondering if anybody from South 24 Parganas is involved.
Yes.
Anyone?
So I think, Mr. Chatterjee, you can take instructions from your client. I think this is not a matter which is to come before the court.
The point is interesting.
Point is
Very
interesting. No, point is interesting. That is why Mr. Chatterjee started with that.
Yes.
Point is interesting, but it
Right.
might be in a
Only
different
one-
matter because
Only one small submission, my lord. Only one small submission.
এই সাবমিশন করবে তারপর বলবো যখন বলেছে তখন বলে না আমি তো কিছু বলিনি।
My lord, he has justified his presence. I need to. Only my lord, the development agreement, it says that the developer has satisfied itself to the title of the property and has obtained the certified copy of the title deed from the plaintiff.
certified copy,
Yes.
not the original.
No, no.
He wants the original.
The development agreement, it records.
Yes.
It records.
Yes.
And thereafter,
No, show me that. No, Mr. Chaturvedi, you can also take instructions on this. Whether the original or the certified copy of this is with
has
him.
been given. Original also has been given.
All right.
The agreement records. The agreement records that he has satisfied himself with regard to it. So once, my lord, the title has been verified, he is satisfied. So he does not require the original title deeds anymore.
That is why Mr. Chatterjee, Mr. Chaturvedi, unless Mr. Chatterjee takes
No,
instructions.
no, not on. I am not on the instruction. I am yet on the application. So I am the developer. I have satisfied myself with regard to the title of the property. So now I don't require the title deed anymore. I say that anything which is superfluous to the development agreement cannot come within the ambit of 8 and is hence not arbitrable. I have judgment, my lord, on that issue. My lord, our High Court, my lord, has also held that. My lord, even the Supreme Court has said so. I come to that, my lord, if and when
So
required.
according to you, this return of sale deed in this case cannot be arbitrary. That I will consider that. But now we are on an issue. If this can be returned, this you need not make further submissions on this
My lord.
because you are getting the ultimate relief.
Yes, yes.
I will record that you have.
No, the suit can be disposed of.
Suit can be disposed of. Nothing remains in the suit
Nothing,
because
nothing.
that is your suit. Yes, Mr. Chatterjee.
Gives me this weekend will not keeps it on Monday as to be mentioned, then I'll
I
get
think
some.
I'm keeping it as to be mentioned.
Yes, my lord.
So if you both of you want a hearing, I can fix the date.
So let it come as to be mentioned on Monday, my lord, and we come back.
You also take instructions because you might be saying, yes, you have some.
Yes, yes, it is. না আমি খেয়াল করিনি।
Because the point was that interesting, my lord, we forgot about the time.
This, no. Next matter.
আবার call next matter. Resolution আছে।
Borders.
কেন উঠবে না কেন কি হলো?
Item number 3.
বসে থাকলে তো বসে থাক Lordship rises 3:30.
I'm asking you, what do you want?
So if my lord is rising, my lord, we can't leave.
হ্যাঁ
I'm telling the other way around.
একই বিপদ। But if your lordship is rising, my lord, we cannot leave.
Yes. Yes, Mr. Rai, where is your other? You have served
Yes. Evidence service is
for the
there.
other side.
প্রবালটা শেষ হয়ে যাও, আমরা বেরিয়ে যাই।
Mr. Side.
কারণ আমি ছবি তুলে রাখছি, তুমি 3:30টার পরে মামলা করছো।
You are for the opposite party. Yes.
But your lordship asked me that to assist your lordship, Lord, whether
Yes,
not
Mr.
this
Bhattacharya,
order
are you
is-
ready? Have you gone through?
My lord, I have got a judgment also in this matter. I need some more time.
You need some more time. Yes, Mr. Mukherjee, what do you say?
But I say, Lord, it's a revisable order. Why I say? If your lordship kindly seeks order 26, rule 14.
Rule 14.
Lordship, because Lord, that is the provision concerning, Lord, the commission, Lord, appointed in case of partition. The question of acceptance or Lord, variation is a stage prior to Lord, passing of the decree.
The commissioner shall, after inquiry as may be made, divide the property into as many shares as may be directed by the order. Shall allot. So it's the commissioner shall then prepare and sign a report that is determining such report shall be annexed to the commission and transmitted to the court, and the court, after hearing any objection which the parties may make to the report, shall confirm, vary or set aside the same. Where the court confirms or varies the report or reports, it shall pass a decree in accordance with the same as confirmed or varied. But where the court sets aside the report, so that is, we are not on that. Sets aside is a fresh thing is to be done. So if confirms or varies,
yes,
then it shall pass a decree in accordance with the same as confirmed or varied. So Mr. Mukherjee, one thing, the commissioner files a report. Objections have been filed, evidence and other things done. Court applies its bind on the commissioner's report. Let us keep aside the case of setting aside the report for the time being. In the case where the court arrives at a finding or decides, we can say, confirming or varying, may say, yes, this has to be varied or that thing, or confirms as it is. So passing a decree is a mechanical job, a ministerial job, we can say. The decision part is with regard to acceptance, confirming or varying. That's the application, that's the decision.
That is, Lord, I agree to what following from your lordship, Lord, provided, Lord, by a single order, acceptance is followed with, Lord, passing of, Lord, the final decree. Then, Lord, the question about, Lord, the acceptance merges with the final decree, it is appealable.
Yes.
So let us take, for example, Lord, that in this case, it is an order prior to passing of the final decree.
Where is that order?
And Lord, the division bench that my learned friend has, Lord, relied upon, Lord, Mr. Rai, I mean to say, ওটাতে কোথায় এই প্রপোজিশনটা আছে?
It is not in that sense. It is the case
where is the order? Impugned order?
4th of April. 4th of April. Acceptance of the commissioner report.
4th of
acceptance of the commissioner's report and directing, Lord, the partition commissioner to be appointed.
Sir,
in
where
respect
is
of
the
partition to the
certified
defendant
copy?
number
It's very
1 and
difficult. You have given this bunch. Difficult to find
প্রথম
out.
দিকে আছে, প্রথম দিকে আছে।
Last year.
প্রথম দিকে আছে, পার্থ, প্রথম দিকে।
First order.
Order number 190.
Why have we annexed this much of
We can, the entire applications is made. No.
6/11, what is the date of the order?
Lord, 4th of April 2024.
4th of April
2024, order number 190.
Oh, 4th of April 2024.
That will be, Lord, your Lordship will find.
Yes, yes, 4th of April 2024. So this is
মাঝখানেও তো এক গাদা অর্ডার আছে
অনেক কিছু আছে
তোদের আলাদা কপি আমার আলাদা কপি
No, this is fixed for commissioner's report.
Probably my lord is not. This is an application filed by the defendant. The plaintiff application was accepted. Commissioner was accepted. Initially, my lord.
And where is the which order?
Same order, my lord. Before that. Before that.
One part for the plaintiff it is accepted.
And defendant.
The commission was allowed. Because there was a previous order directing Lord the property to be partitioned between the defendant.
So, commissioner's report dated 9/5/2016 submitted by the land partition commissioner is hereby made part of the case record.
Yes.
Plaintiff and the defendant is directed to testify for completion of the final degree petition. Defendant was filed a petition with for effecting final degree as per the preliminary decree. Defendant have paid for appointment
for their partition. Initially, the allotment was made in favor of the plaintiff. The plaintiff applied for preliminary degree was passed, declaring the plaintiff share.
Yes.
Now, my lord, the plaintiff filed an application for final degree, pursuant to which the final commissioner filed this report. That report was accepted. Subsequently, in the meantime, the defendant also filed application for final degree for their allotment.
Yes. So, Mr. Mukherjee, that report was accepted.
But it didn't follow up with Lord the degree automatically. It was because of the defendant
What
1 and
remains,
2.
what remains, Mr.
But then
Mukherjee,
there will be
that
two
is-
final partition degree in this case.
No,
Because
that is, there are two things.
there might be multiple preliminary degree. But so far as the final degree is concerned.
To be one. No, that is on merits.
That is on merit.
That point has been
The
taken.
point that your lordship was Lord mooting to decide. Lord, that was Lord whether Lord the acceptance of the partition commissioner's report is an appealable order or a revisable order in itself.
So, till if we take up the first part only, that plaintiffs on the plaintiff's application, the commissioner was appointed, submitted, commissioner's report accepted. So that is confirming the commissioner's report. Court applies its mind, accepts that,
and shall have to pass a degree. Shall pass a degree. That is not the statutory language. Therefore, it not says that it is a stage prior to not passing of the degree.
No, 14 if you come, 14 says
Lord, whether
Hearing
court
any
confirms or
objection-
varies the report or report, it shall pass a degree in accordance with the same. Therefore, Lord, the variation or confirmation is a stage prior to.
Order 26, Rule 14,
Yes.
which subclause?
3.
Yes, where the court confirms or varies, it shall pass a decree in accordance with the same as
Confirmed or varied. So, Lord, this is a stage prior to Lord passing of the degree. The
Oh, yes.
confirmation or variation is a stage prior.
Yes. 2 says,
Yes.
2 after hearing the objection shall confirm, vary and set aside the same.
Lordship.
So according to you in this case, it's stage 2,
Lordship.
subrule 2.
Lordship.
So it was not followed by subrule 3. So once subrule 3 is there, it's appellable.
By a single order acceptance, final degree is passed, appealable. 105 will apply. In case of Lord, the acceptance order. But Lord, when there is a separate order accepting or varying, Lord, in my respectful submission, Lord, it should be Lord a revision law. Because it has not been followed with a decree. It is ipso facto not a decree.
Unless the decree in accordance with that is passed.
We fall back on the definition of order in section 2. It's an adjudication on an objection.
Yes, but Mr. Mukherjee, if other cases, let us forget about this partition suit. What happens when the initially judgment is passed.
Lordship.
The operating part is the decree, as we tell at some times when the decree, we do not get the certified copy, we can say that the ordering part is the decree.
Lordship.
So what is the ordering part? That's the final adjudication.
Lordship.
So now, let us take a case where a judgment has been passed, but it takes time to prepare the decree.
Formalize the decree.
Or formalize the decree, because it also will be at the date of the judgment. So that's the formal part. It's a ministerial job. Nothing with regard to any adjudication, application, or deciding the rights. Rights have been decided in the judgment. So it's only the ministerial job. So can we not take it that when sub-rule 2, it has crossed the stage of sub-rule 2, sub-rule 3 is only a ministerial job?
Lord, in that even, Lord, that...
Because if, let us take that the decree is yet to be drawn.
Yes.
Judgment is there. Now you cannot wait till matter is so urgent. You cannot wait till the drawing up of the decree. You can pray for exemption or for dispensing with the filing of the decree. You can file an appeal from the judgment itself. No requirement of the decree. Or we can say that can be dispensed with, because it's nothing, only the ministerial job.
Lord, your Lordship
So
will
here also whether sub-rule 3 can be said to be a ministerial job, because the ultimate adjudication is up to sub-rule 2.
But yet again in 3, my Lord, it conceive of 2 stages: variation, confirmation, and shall pass a decree.
Yes.
Therefore, my Lord, this imports that first, my Lord, it should be by confirmation, variation. Lord, if it is immediately followed by a single order, as I say, Lord, it is appealable because of a decree is passed.
There is
no problem.
Yes.
But here, Lord, if I take the confirmation or variation order under Order 26, Lord, Rule 14, Sub-Rule Lord 4, Lord, it is not an appealable under Order 43. We do not even find it, Lord, under 104.
Yes, not an appealable order.
Not
either it's a decree or a revisable order. It's not an appealable order, not under 104.
Then, Lord, your Lordship has to interpret that it is the order which is, Lord, accepting or varying.
That is the final adjudication. That is the final adjudication.
That is a dim decree. Then only, Lord, it becomes an appealable order.
Mr. Rai, what do you say? Mr. Mukherjee, have you brought any decisions in this?
So, Lord, this is, Lord, on this point, my learned friend has relied upon a division bench. I could not find, Lord, the ratio that...
What? Why, my Lord? I have handed over to your Lordship on the last occasion.
Kindly have a look at...
I think there are 2 liner decisions,
The
Mr.
division bench
Rai.
not only, Lord, applied for 100 fines.
No, it's on the ground. What is fallen from your Lordship? That is precisely, my Lord.
Where is that, Mr. Rai? No decision is here.
Yes. আগের দিন দিলাম যে
Justice Bhattacharya?
হ্যাঁ সুভাষ ভট্টাচার্য সে জাজমেন্ট
প্যারাগ্রাফ কত?
20 এটা আলাদা, এটা পার্টনারটা যেটা তোমাকে একটা দিয়েছে পার্টনারটা, ওটা নয়, এইটা প্যারাগ্রাফ 21 দেখো।
Mr. I do not have copy.
Well, I can hand over my copy.
I'm reading out after the settled proposition of law might be that no title devolves finally on the basis of the final degree unless proper stamp is...
Which paragraph?
Paragraph 21. Final degree unless proper stamp is affixed thereto in terms of the final degree. However, even we proceed on such assumption, it does not entitle the final degree loses its character as a final degree once it is passed by the court. Once the court passes a final degree, it has binding effect on the parties and conclusively determines the right and liabilities as well as the title of the parties. The subsequent ministerial work left regarding drawing up decree and putting the proper stamp thereon does not vitiate the existence of the final degree itself.
Yes, so drawing up of decree, so that's the only thing. So it's sub-rule 3 is only drawing up.
That
is dealing with a different blood of acts. One of the property not included in the the preliminary decree was not part of the commissioner's report.
But
that
here,
was not the sum and
I accept, but 21 is the reiteration of a settled proposition.
Yes.
So it's not on facts. No. So it's reiteration of a settled proposition. There what it says, once the court passes the final decree, it has binding effect and conclusively determines the rights of the parties as well as the title of the parties. The subsequent ministerial work left regarding drawing up of a decree and putting thereon does not vitiate the existence. So it's only, Mr. Mukherjee, it's only drawing up. It's a ministerial job. Sub-rule 3 is only the ministerial job.
Not necessarily. Kindly
As in
conceive
paragraph
of, my lord,
21 also.
Kindly conceive of at a stage. Suppose, my lord, the drawing up of the degree or passing of the degree takes not a time.
Yes.
So in this particular case, the defendant made an application for commission. That commission has been ordered by the impugned order. My learned friend's contention is that, well, acceptance of, my lord, the first commissioner's report qua the plaintiff's property, you pass a decree or deem it to be a decree.
Whether that can be done in a piecemeal manner.
Although he is challenging that acceptance, but my lord, the point of law that emerges here is that
The two final deeds, that is subject matter, that is on the precisely my lord, on the very beginning, whether my lord is accepted as a decree, then my lord, there is a segregation. But whether my lord, as on this day,
because one order, my lord, accepting and my lord, relegating, my lord, that the drawing up of the degree or passing the formal order of the degree.
That, Mr. Mukherjee, can be decided or can be entertained only if I decide that revision is
Then
better.
there will be two, my lord, a set of appeals.
No,
Kindly
if I decide to take to consider or entertain the civil revision application, I can go into that.
Yes.
So, but if
but kindly conceive of a situation, Lord, where acceptance of Lord of commissioner's report is appealed against, and thereafter, Lord, there is another Lord appeal might be after Lord the formal degree is drawn up. A first appeal against Lord a decree by either of the parties to a partition.
let us come back, my lord.
one thing, Mr. Rai, the final degree has not yet been drawn up. What is your instruction?
No.
You have taken. No, he will say no because his application has been commissioned. He will say no. Oh, you are the defendant.
As the defendant,
Oh.
I challenge the acceptance of the commission. Two things, my lord.
Oh, I was thinking that
No,
he is the
They
defendant.
objected.
Two things, my lord, can be considered. Whether the engrossment of a degree, enforceability and executability.
Mr. Rai, there is a Supreme Court judgment.
Justice Banerjee's.
When the execution, from when the limitation will start.
That is the enforceability of the degree and the executability of the degree.
The earlier view was subsequently
Yes,
set
yes.
aside. What will be the starting point of the period of limitation, whether on the putting of the stamp duty or from that date?
And I am aboard the submission of Mr. Mukherjee. Latest Supreme Court has said it is not the duty upon the parties to apply for the final degree. It is the court who should fix the date for the purpose of drawing a final degree.
Yes, it's the court's job.
No,
It's not-
initially it was that as and when somebody can apply for the final degree of the preliminary degree.
That is for the putting in the stamp duty when it will be.
That also that is why the enforceability and executability.
Yes, yes. That's the decision which says when the limitation starts.
So that
There it has been used, these two expressions, enforceability and executability.
that is why those are triggered to be placed before a lordship.
Yes, Mr. Bhattacharya, what do you say?
Kindly comes to the order input.
Order input পরে
Not the order.
না appeal হবে না revision হবে
বল আগে বল appeal or revision.
In my humble submission, its appeal is favorable. May I
Appeal is
appeal, not revision. May I desire a judgment?
single bench, division bench.
Single bench.
He has shown division bench.
কোন স্টেজে হয়েছে আগে তাই
Oh, provides to one.
ও 115 এর ওটাতে that is the embargo under 115.
Yes, yes, maybe 115, but it says it's appeal.
The last
Appeal of a revision.
Though the revision is found not maintainable, reversing the right of the party is whatever challenges available to him against the conversion.
It regards to the right mandate sub-rule 2, what I was saying. Sub-rule 2 is
That is why, my lord, on the very beginning of submitting.
But it negates, my lord, the right of division against that interlocutory order accepting it.
But the judgment which has been.
It says that you have to wait for the final
yes.
degree.
So 115 was considered
And you have to wait for the final degree to challenge the acceptance of the commissioner's report. That is always there under 105.
100. Yes.
Always there.
That is why, my lord, if you logically consider the Patna High Court judgment.
Patna High Court was also on this point.
Patna High Court said what?
Revision. That is a more, lord, a detailed judgment.
Details judgment possible.
Yeah, your lordship will kindly have this.
কোথায় নেই তো
Yeah, paragraph 7 onwards, paragraph গুলো
কোথায় রাখলেন এসব বলছে যে দিয়েছিল সব হ্যাঁ বলছে সব উকিল বাবুরা বলছে সব দিয়েছিলাম কোথায় গেল
7 onwards. Lord,
722 has been considered.
yes, thereafter, Lord, your lordship will kindly see, Lord.
Order 43 rule.
Order 26, Rule 14, to appoint such and such. Sub-rule 3 stipulates the power of the court either to confirm. Paragraph 10. Appeal can be filed under 96 against an order confirming the report of the pleader commissioner or not. After such order confirming the report, the moment the final degree will be prepared, the petitioner can move in appeal. The argument of the plaintiff is like this: as against the judgment in the petition, no one can move in civil division, but only after the preparation of the preliminary degree. The situation, it is argued that the order is passed confirming it is argued. Where is the finding? Now, in such a way, there may be cases in which, when judgment is delivered in a partition suit, shares on the preliminary degrees period, a party may not be aggrieved. Party paragraph 11. Yes.
11 the page, previous page.
In such a situation, can a party move in as suggested? According to me, it cannot move an appeal under even after preparation of the final degree.
After that, paragraph 11 onwards, ballot can consider.
Paragraph 11, Mr. Wright says, according to me, it cannot move in appeal under section 96, even after preparation of the final degree.
After that, well, that is why ballot can
97 is very specific. From filing appeal under section after the final degree. Oh, this is preliminary degree. If you have not challenged, whether you can challenge. 97. Apart from final degree, when no appeal from the that is, I think, this is on 97.
No, after that, ballot can
Oh, I think last page, the appeals were admitted by a single judge of this court, but we are of the opinion that it was by some oversight. No appeal will lie against an order by a court confirming or varying a report to make a partition under Order 14, Rule 14.3. Order 14, Rule 1 provides that an appeal shall lie. 26 finds no place. What is this order? I think it's Order 43 or Order.
Rule 1.
But it has been all XLU. It has been Order 40. This cannot be an order appeal under Order 43. It will be an appeal under 96. Cannot be Order 43. There should be a right of appeal against the preliminary degree in a case. I think this was not decided on that. It's purely on 97. If you have not challenged the preliminary degree, final degree, that's well
settled.
That's court confirming the report of a pleader commission in a partition suit is not applicable.
You could not, Mr. Mukherjee, also you could not find any direct
But I
decision
have
on
got
this.
decisions on, my lord, what constitutes degree. I can take your lordship to all those. What constitutes deemed degree, my lord? We have also argued that in a different matter. But I can assist your lordship. But
But
here,
you have not got a direct decision on this.
But the only thing I can assist your lordship by interpreting, my lord, that Order 26, my lord, Rule 14, Sub-Rule, my lord, 3. To say that, my lord, in a particular.
Hand over to your lordship, my lord, the all.
No handing over those judgments only. Please make submissions, Mr. Rai, because it's an not be today because this is a point.
This is the point, my lord, your lordship may kindly decide, my lord, because we all, my lord, need a guidance from your lordship. In my respectful submission, my lord, stage prior to, my lord, formalized degree, my lord, will be a revision. If it merges with the, my lord, the degree, obviously, my lord, the first step.
So you are
otherwise,
trying to make
there
a
will be a
distinction that if it is followed by once a degree is passed, after confirming, then it's appealable. Prior to that, any stage, it's revisable.
Lordship. Because otherwise, your lordship has to hold this to be a deemed degree.
The merits, please satisfy me on the issue of maintainability, because That part I can go after I try to entertain this. When
Because even the division bench, my lord, Justice Bhattacharya's, my lord, the division bench, my lord, his lordship was also considering, my lord, that point of 105. There also, my lord, the partition commissioner's report was set aside in the first step itself.
and there it's a question of proper stamp duty, but the last sentence is that
That might not be very helpful for our
drawing up of a decree. Here is also drawing up a decree because after the court says acceptance and confirming.
Here, my lord, it is far to go for drawing up of the decree in this particular case.
Yes.
Because, my lord, at the instance of the defendant, there has been a commission. Commission has been ordered by the impugned order. The commissioner report will come, confirmed, varied, or set aside. There cannot be two final degrees on this.
Multiple preliminary degrees.
Multiple preliminary degrees can be there because of the shares. But so far as not the final degree is concerned,
has to be one because otherwise, once an allotment has been fixed, how can the allotment, the other portions intersect that can be.
Lordship. And the defendant says that the acceptance of the commissioner's report at the instance of the
I'm giving it to you.
petitioner is
Mr. It's Mr. Mukherjee's copy. That is why. Please take it back. Otherwise, we will make allegations on the next day where it has gone. Ashun.
If your lordship desires, Lord, I can give your lordship the lineup of judgments, Lord, which Lord the calls upon Lord that deemed degree and Lord what should be constituted to be a decree.
Here it's not a deemed decree in the sense because once it's
difficult, Lord.
Whether it's a decree or no decree, because it's deemed decree is under statute. Some
Final adjudication of sort.
Yes.
But there is no.
Order 21 says about deemed degree. Rejection of plaint is also not a deemed degree. It's a decree itself.
It's a decree itself.
It's a decree itself. So order 21 by that provision it says it uses the expression deemed to be a decree. So it's either a decree or a no decree. That stage is.
That is why the enforceability and
executive.
that would always
Please consider that. Please give
I mean,
the reference to Mr. Mukherjee.
I know that, Lord. That is on the purpose for the purpose of Lord putting the court fees, Lord, on the.
It was a ministerial work. It was
Yes.
really that.
Stamp.
That is not pursuant to section 54 of the Act.
Yes.
I'll supplement.
Code of Civil Procedure.
Just আমি সব দিয়ে দেবো বলে দেখুন
Yes, when you can come. Every day.
Mr. Mukherjee, আর কিছু হলে আপনি Mr. Mukherjee.
Mr. Mukherjee,
Whenever your lordship pleases me. Whenever.
Next week.
4টের সময় টময় রাখুন সেটাই সুবিধা হবে। কবে হবে?
I'll come with a written notes, Lord. I'll give a copy to my learned friends. So that, Lord, the time is shortened.
কোথায়? 4টে? ফাঁকা?
আরো পরের দিকটা
29th, 4 p.m. Heard Mr. Mukherjee.
Hundreds for time, I can appreciate. Really, there were very urgent matters. 4 p.m. order.
4 p.m. matter?
No,
What is that item?
ID is 679.
679.
That lordship trial court has given the last chance as this Friday. I can appreciate my difficulties, but I am also absolutely something else. What is it? What is that?
All right, I will consider this 679 mark করে রাখুন।
Anytime that shifts your lordship from after 11 to 4, anytime that shifts your lordship.
Yes, I will keep it in mind. I will fix.
Less than mentioned time. No caveat is there.
Who is any caveat is there?
No caveat is there.
All right.
Lord, the 111.
Recording and they order not complied with order 20 not complied with. Catholic court has directed to there that has not been heard.
All right. All right, I will consider.
Lord, 111, Lord, the 3 p.m. fix up, Madam, Lord, the expeditious disposal of the injunction application.
Tomorrow, come tomorrow. Yes.
Next matter, my lord.
3 p.m. fixed. It may be fixed to tomorrow 12 p.m.
My lord,
12.
Tomorrow 12 was
Let me see if it will appear tomorrow.
serial number 4, my lord. কালকে